all persons having business with the appellate division draw near, give your attendance, and shall be heard. Please be seated.
Good afternoon, everybody, and welcome to the Appellate Division First Department. Glad to see you here today. We have about 5 hours of oral argument time that's been requested, so I have to remind you that we have had your briefs and records, had a chance to read them, so please just ask for the time that you really need to get your important points through. When the white light goes on, that means you still have 2 minutes. When the red light goes on, that means you should finish up your statement. If we continue to have questions, we will, however, ask past the red light. Okay, let's call the calendar. The first case is People versus Baptiste. Both councils will please rise. Appellant?
Your Honor, appellate request 7 and 2.
And okay, I'll give you 5, 2, and 5. Thank you. Binsler versus Lenox Hill. Okay, and respondent? I'm going to do 5, 2, and 5 also. I think that should be good. 938 St. Nicholas versus Cliff Crest. Okay, I'll give you 6 and 2, and I'll give you 5. Thank you. Moon 170 versus Vela. Welcome back. Okay, let's do 6, 2, and 6. See how that works. The next case is Citizen Watch versus 1500 Investment. Zapco 1500 Investment. Respondent?
Yes,
Okay, 4, 1, and 5. Thank you, counsel. Perfectly Reliable versus 213 East 26th Street, etc. You got it. 5, 2, and 5. People versus Angel Gomez. Okay. 2. Okay. 5, 2, and 2. Hobish versus AXA Equitable. Plaintiff appellant. And respondent. Yes, you have a cross appellant. Okay, I'll give you each 8 and 2 on that case. Thank you. People versus Hernando Ruiz. Okay, I'll give you 6, 2, and 6. Storch Amini versus Schlackett. Appellant 5 and 2, and respondent 5. Okay, 5, 2, and 5. Moy versus Mount Sinai is submitted. Simpson versus McKendrick is submitted. And in the matter of Carlos Casañas is submitted. First case for oral argument, People versus Stephen Baptiste.
May it please the court, Samuel Steinbach Pratt from the Office of the Appellate Defender on behalf of Stephen Baptiste. It's undisputed that 4 separate jury notes go entirely without mention in this record. I want to focus the court's attention on just one of those notes in particular, the one contained in Court Exhibit 9. That note was substantive for at least 2 reasons. First, it requested an exhibit that was admitted only for demonstrative purposes, and second, it was ambiguous. This court has never held that a note with these characteristics is merely ministerial. The court was therefore required to give counsel notice and the jury a meaningful response. Because it did neither, Mr. Baptiste's convictions must be reversed. First, Court Exhibit 9 requested an item which was admitted only for demonstrative purposes, specifically an exhibit which purported to link certain phone numbers with certain names. The Court of Appeals held in Mendez that requests for demonstrative exhibits are substantive, not ministerial, and the failure to address such notes on the record requires reversal.
Counsel, in the beginning of once the notes started coming in, there was a colloquy between the attorneys and the court where the court inquired as to whether or not the attorneys would consent to providing the jury with any items without reconvening. And does that play into your argument at all?
I don't think so, Your Honor, for a couple reasons. The first is that none of the defense attorneys, and certainly not my client's attorney, ever actually affirmatively consent to sending the exhibits back. There's sort of a back and forth about how they might handle different requests, and my reading of the record, at least, is that it ends on a very, well, we'll see what happens note. And that's certainly consistent with how the court actually handles the requests, where they actually go on the record to discuss a number of requests for exhibits in some detail, including ones where the parties seem to agree. But particularly with respect to this aspect, the fact that it requests a demonstrative exhibit, that is the subject of a specific exchange where the parties point out, there might be demonstrative exhibits, and the court draws a line between items that are in evidence on the one hand and stuff that was purely demonstrative on the other. So I think at the very least, even if you think there may have been consent for other requests, there certainly was no consent given for demonstrative exhibits, again, like what is requested in Court Exhibit 9.
What did Court Exhibit 9 ask for?
Sure, Your Honor. So Court Exhibit 9 had two parts. The first part is a refund request denial form, and the second part is the sheet that identifies the phone numbers for the text messages. The second part is what I'm talking about as demonstrative. That's what's marked as Exhibit 500-14, and it purports to match up a list of phone numbers with a list of names, and it's admitted only for demonstrative purposes. The first part of the request, though, brings me to the second issue with this note, which is why it required notice to counsel, which is that it's ambiguous. There were 3 separate refund request denial forms relating to 3 separate customers, only 2 of whom were testifying witnesses, that were admitted into evidence. So which of these forms the jury wanted, it could have received any one of them, and counsel was entitled to have a say in that. Maybe counsel would have preferred that they receive one that related to a testifying witness or not related to a testifying witness.
Counsel, on page 2790 of the record, there is a reference. I mean, unfortunately, these, as they're going in, there's no reference to this is Court Exhibit 1, 2, 3, or 4, and so on. But on page 2790 of the record, there is a reference to the jury requests more refund request forms. Are you saying that that's not the one that was addressed by the court?
That's correct, Your Honor. That's actually a separate note. I'm not sure I have the number off the top of my head, but that is actually a separate jury note from the one that we're talking about. The jury note that we're talking about is one that is never addressed on the record, along with 3 others that go completely without mention. It appears they responded to this later note. It's not clear whether there was any response to this earlier note. Certainly there doesn't appear to have been any notice to counsel. And that's one aspect that I just very briefly want to touch on, that I do want to talk about the restitution, which is there's no evidence in this record of how the court responded to these requests or if it responded. And that's an independent problem requiring reversal. Again, that's the Court of Appeals in Mendez. There's no evidence the court actually responded to these notes, and we don't know what it did with them if it did respond. Just very briefly on the restitution point. The Court of Appeals in Titsakalakis was pretty clear that the prosecution needs to account for offsets. I think it's undisputed they didn't do so here. There's numerous offsets that are documented in the trial evidence. There's the value of the courses themselves, there's the value of licensure for the people who obtained them, and there's the payment of the fingerprinting and licensing fees, which is about $140. That should have been deducted from each of the customers in the ultimate restitution order, and it's quite explicit that no effort was made to make those deductions. That's a facial problem with the restitution order. It's facially inconsistent with the trial evidence, and there should have been a hearing to address that.
Okay, thank you. We'll hear from the people.
Good afternoon, and may it please the court, Catherine Murata for the people.
So what, if anything, does the record show as the court's response to Court Exhibits 9 and 13?
Well, as an initial matter, defendant's ORAMA claim is unpreserved because the jury notes at issues do not even implicate ORAMA or the 2 prongs for meaningful notice or meaningful response.
Does the record show any response to these notes? 9 and 13.
There is no discussion in the record about notes 9 and 10, but they are just easily discernible exhibits that were just sent back to the jury room.
But what evidence is there that they were actually sent back to the jury room?
The jury's request for the jury's notes request for exhibits falls under CPL 310.20, not ORAMA or 310.30. So that actually involves the conversation that Justice Kennedy said before about before deliberations. The judge said, if counsel has no issue with sending exhibits back, he only has to afford an opportunity to be heard.
I'm sorry, you made a
Defendant's
reference to,
counsel- I'm sorry.
one second. You made a reference to Justice Kennedy.
Sorry,
Are you talking, what are you talking about?
I'm sorry. I'm sorry.
Oh, okay.
Yeah. The discussion prior to deliberations asked two counsels whether the court proposed procedure about sending the exhibits back. Counsel remained silent. But that's all that the court had to do, afford the
So
parties.
the record as such doesn't show that anything was done for exhibits 9 and 13.
Right,
There's no specific reference to them in the record.
No, because they were just sent back per the agreement under CPL 310.20.
Well, but there was no agreement with defendant's counsel. The only person who is quoted is co-defendant's counsel. So how is that an agreement?
Well, under CPL 310.20, there doesn't have to be an agreement. The court only has to afford an opportunity for the two parties to be heard. The court said, I'm intending to send these exhibits back unless you have any issues. Counsel remained silent. Thus, he afforded both parties an opportunity to be heard on the matter.
But that was a prospective matter. Later on, when these court exhibits, later on when these notes come in, there isn't a renewal of the fact that, do you have any response to it? I mean, and what do you do, let's get to the bottom line. What do you do with defendants' contention that these notes required input because they could have been responded to in different ways, and therefore it's not enough to say, well, you've agreed that I'm going to send back the exhibits, and I just sent back the exhibits?
Well, these four notes at issues, these four jury notes at issue did not require further input. They did not deal with requests for information or instruction. They were just easily ascertainable exhibits.
Yeah, but you've just heard counsel argue that as to Court Exhibit 9, that there was more than one form that was an issue. And why wouldn't there be a need for defense input as to which form is going back to the jury?
The form's exactly the same. It's just because there's more than one form doesn't mean that it's ambiguous. It just can pull the exhibits and send it back to the jury room. Defendant's argument is premised on the fact that this is based on ORAMA, but this does not implicate ORAMA. This is strictly under CPL 310.20, which once the court has afforded an opportunity to be heard of both parties to send the exhibits back when there's no issue, then the court can follow such, which is what happened here. There was 12 jury notes. The rest of the jury notes, which required input or were substantive, the court did bring the parties back and discuss it. If there was
The jury did not ask for these exhibits by exhibit number. They, in essence, sent in a note requesting a particular document. And speaking about Court Exhibit 9, the request is a refund request denial form that has been signed by someone at Alliance. Now, I saw that there are 3 different exhibits that pertain to refund request denial. Were they all signed, or were some not signed? And if so, then how could the court know what it was that they were requesting?
that form was all signed by someone at Alliance. And Court Exhibit 9 is the demonstrative aid, but with the refund request denial forms, they were all signed by someone in Alliance, actually by the same person. It was just a standard form that they wanted to see. It wasn't ambiguous. It was just because there's more than one exhibit that satisfies the request, it was basically the same form. And as far as the demonstrative aid that Court Exhibit 9 that the defense relies on, that was just, again, just a list of phone numbers, another easily ascertainable exhibit that per the conversation prior to the deliberations, they could just send it back. They're just ministerial notes, not substantive. When there's no issue determining what exhibit they're referring to, they could just send the exhibits back. In contrast to the other jury notes where they had to call the parties back and determine what they were asking for and seeking clarification with the other exhibits.
Now, we've spent a lot of time just on Exhibit 9, but there are other exhibits that they requested that there's nothing in the record about what the court did with respect to those requests from the jury. For instance, Court Exhibit number 8, Court Note number 8, right? They're requesting Botex handwritten pitch from the LV bag.
Right,
What
those,
exhibit is that?
that is one of the 4 notes that was just sent back directly into the jury room, per the conversation prior to deliberations. Since that's an easily discernible exhibit that they can just find, the people had everything well labeled with the exhibit numbers. They don't need to call the parties back. It's not pursuant to ORAMA. The 2 prongs of meaningful notice and a meaningful response are not triggered. It's only under CPL 310.2 subsection 1, where in the court's discretion, they can send exhibits back into the jury room as long as they accord the parties an opportunity to be heard, which was done here. The court satisfied that. And since there was no issues determining what those exhibits were, they could just send them back. In contrast to the other exhibits, as there was more than one text message, they had to come back and redact that. They had to determine that some checks were sent to the state, so they had to come back and seek clarification on those. But here, there was no need for clarification, and per the conversation prior to deliberations between the court and the 2 parties, they could just send those back.
Okay, thank you. I think we got that.
Thank you.
Thank you for answering the questions. Defendant, you have 2 minutes.
Thank you, Your Honor. So just first of all, respondent had mentioned that these exhibits were just sent back to the jury. I just want to reiterate, there's no evidence of that. As far as I can tell, it's entirely speculative. I also just want to be clear that the notes that weren't addressed are Court Exhibits 7, 8, 9, and 13. And in fact, it's notable, I think, that the parties are discussing in open court Court Exhibit 6, and then the court says, and this is at 2790 of the transcript, I have another note, and then goes on to describe Court Exhibit 10, totally skipping over the others, and there's none of the parties ever mention any of the others. There's no indication of how they were handled or that there was notice.
But when the record is silent on these matters, when, if ever, is a remedy for this to send it back for a reconstruction hearing?
I think the Court of Appeals in Parker was pretty clear that the only remedy in this situation is reversal and a new trial. I think they pretty emphatically rejected the possibility of a reconstruction hearing as a remedy. And then I just want to mention, the respondent also said that the forms that were requested by Note 9 were identical. That's not true. In addition to the fact that they were signed by different people, the printed portion of the form is the same, but in addition to the fact that they're signed by, or that they relate to different customers, one of them also has handwritten notations of uncertain origin. So they're certainly not identical, and they differed, I think, in respects that counsel might have cared about and should have been given an opportunity to weigh in on before it was returned to the jury. And then the last thing I just want to say is that it's not true that the parties just reconvened for notes that they disagreed about. They reconvened in open courts for some notes that just requested exhibits, even when there was no apparent disagreement. They went on the record and they said, we got this note, we responded to it in this way. They do that for notes 4, 10, and 14. So the fact that these notes are totally absent from the record, I think really undercuts any inference that the normal procedures were followed, that counsel was given notice, or that a response was provided.
Okay, thank you. Thank you.
Thank you.
both. The next case for argument is Bindler versus Lenox Hill Neighborhood House.
Good afternoon, Your Honors. May it please the court, Irina Kravchenko, I represent defendant appellant Lenox Hill on this appeal. It is Lenox Hill's contention that the motion court erred in denying its motion for summary judgment. Your Honor, this case is simple. It doesn't involve a dangerous condition on the premises. There was nothing wrong with the floor. It doesn't involve intoxication or drinking. This is just dancing. This is simple dancing, an event that was routinely held.
I know it's not the basis on which it's not the plaintiff's theory of the case, but as you look at the video, wasn't that dance floor pretty small for the number of people that were going to be using it?
Yes, Your Honor, as you mentioned, this plaintiff did not adequately preserve this argument. However, to the extent that it is considered, the size of the room was not the proximate cause of the incident. You see Mr. Dawson, who's the gentleman that fell on plaintiff, they had plenty of room around them to actually dance. Mr. Dawson, in his dancing, he was not bumping into people. He was not, the person he was twirling was not bumping into people.
Well, he was moving quite a bit, and it only took about a second, and he did bump into took a misstep, bumped into someone, and then fell on the plaintiff.
Yes, Your Honor, he did unexpectedly fallen because he has lost his footing. He didn't lose his footing because there was no room. He simply unexpectedly lost his footing, which led him to fall forward and then fall backwards. So that event in and of itself had nothing to do with the people in the room, it had nothing to do with the type of dancing he was doing, and it had nothing to do with the music he was doing. The case law on this issue, which determines the realm of liabilities, centers around foreseeability, and that finding is made based upon prior experience. Is there a reason, is there notice for the defendant to have believed that this may occur? In this case, the record is uncontroverted that during these routine dances, they were regularly held, and more than that, that plaintiff attended twice a week. There were never any issues with any sort of, with the dances, with the music, with the
Was there any, I'm sorry.
Since you've jumped ahead to foreseeability, does that mean that you acknowledge that your client had a duty towards the people who were present that day?
No, Your Honor. It is the Lenox Hill's position that the duty was also absent. I'm resting on my brief with respect to that, but I would gladly say that there absolutely is no duty to supervise these adults that were not living in Lenox Hill. Nobody was. This is just simply a program that was offered for self-sufficient seniors that showed up whenever they wanted to and participated if they wanted to.
But it's being held on their premises. They're providing, well, there's a musician there. Why are they creating that duty but holding this event?
Yes, Your Honor, it is Lenox Hill's position that the general concept is that there is no duty to control the conduct of a third party. Historically, the duty was extended in the context of a bar, of the situation where somebody served alcohol, etc. And this is a different circumstance. However, even to the extent that there was a duty in this case, the argument as to foreseeability is still the winning argument, and it eliminates liability in this case.
Well, was the foreseeability issue somehow increased because in addition to the people that usually came to the center that day, there were a group of young people from France, I believe, who were visiting to observe and whatever, so it made it more people, younger people, still in the same small area. Could that have increased the amount of foreseeability on that particular day that we need to be concerned about?
Your Honor, it is Lenox Hill's position that nothing changed with respect to these other people being present. The music that was played was still the same. It's not like they were playing, I don't know, they were breakdancing or playing some kind of other music. It was specifically catered to the citizens. It was played by the guitarist who routinely plays the same repertoire, again, that the citizens grew up with. I mean, it was a twist. And the type of dancing was a type of dance that always takes place. And Mr. Dawson's dancing was not actually anything different or unique because of these people present. He was twirling the young person. He wasn't twirling himself. He was standing in place. He was moving up and down and to the side, as the video shows, and he was twirling the young person. And in fact, he was able to do that without any issue whatsoever 4 times, no less than 4 times. There was absolutely no reason for Lenox Hill to believe that when he goes to do this for the 5th time, he'll suddenly lose his footing, which eliminates its liability in this case. I'd like to cite to this court decision in Lizardo versus Board of Education of the City of New York, 7783rd, 437, 2010. There, a student charged another during kickball. And specifically, I'll quote that this court held to impose liability based on the gym teacher's failure to blow her whistle and stop the play before the collision occurred presupposes that the teacher could have anticipated well in advance and that the base runner was going to run directly into another student. I see my time is up. May I finish my point?
Well, why don't you, I think we got the point. Why don't
Okay.
you respond? We'll hear from the plaintiff, and you'll have 2 minutes to respond. Thank you.
Thank you.
Good afternoon, Your Honors. My name is Nancy Markland for plaintiff respondent. It is our position here that defendants' arguments are misplaced. The activities at issue here are not that of plaintiff or Dawson, but they're that of defendant Lennox Hill.
Counsel, but in order for there to be liability, defendant has to owe a duty to your client and to the other people who were there. What is the source of that duty and what is that duty? I didn't find an answer to that in your papers.
Thank you, Your Honor. Lennox Hill assumed the duty by operating and controlling this event
What is the duty that you claim that they assumed?
to make sure that my clients, the people on the dance floor, were safe.
So how would that duty play out? Does that mean that they shouldn't let people dance? Or that they should stop the music every 5 minutes? Or that they what is it that they were, and having watched the video, I can't really figure out what is it that you're claiming that they should have done, even if they had such a duty, which I'm not sure I am convinced of.
Thank you, Your Honor. So it's our position that they should have taken proactive steps rather
What
than
steps?
and more appropriate music.
But they had played the same music from many prior dance events. Your client's deposition, as I recalled, acknowledged that. So why would that music be inappropriate if they'd had dancers using that music many times before?
There are a couple issues with that. My client did testify to having danced at Lennox Hill on numerous occasions. The testimony was that she did ballroom dancing, she did other types of dancing. The repertoire may have been the same, but there's no testimony on the record that this exact fact pattern had taken place before. The twist with young and old people, individuals of completely mismatched abilities, okay?
What evidence is there in the record that the fact that there were younger people in the room would have created any additional risk to the older people who were there?
It's our position that the surveillance tape demonstrates the way that Mr. Dawson was dancing with a young student. And also, I'd like to speak to the fact that defendant has said I didn't preserve the crowded dance floor. I did on page 182 of the record. I actually stated in the uncontroverted facts that the surveillance tape demonstrates the room was quite crowded. And we can see that on the dance floor, this makeshift dance floor. The case that I think is very salient here is Kremerov, where the second department—
But in Kremerov, the activity that was at issue was something that the injured person had never engaged in before, whereas your client had attended, by her own testimony, many similar dances that she described as very, very nice. So isn't that a very major difference between Kremerov and this situation?
Perhaps the difference with Kremerov was that she was a novice and my client had testified to dancing before. But again, in Kremerov, they controlled the event. They put together this makeshift bowling alley. Here, there's a makeshift dance floor. The fact that Ms. Spindler had danced before, but they had not danced in this particular circumstances under this fact pattern before.
There was nothing about the floor that caused the injury, right?
Correct, Your Honor. Ms. Spindler testified that there was nothing on the floor. But the way that Mr. Dawson, and again, our position is that Mr. Dawson was an interchangeable character. It didn't have to be Mr. Dawson. It could have been somebody else. An accident, and we are, of course, saying that Lennox Hill has a duty. So the foreseeability there was that there was going to be something on that dance floor. Something was going to take place. There was a high risk of an incident. And it just so happened to be that it was Mr. Dawson.
And what
Colliding
evidence
with my
is there that there was a high risk of that, other than the fact that it happened once, since there's no testimony in the record that at any other dance, which apparently the center held frequently, that there was ever an incident in the past. So what evidence is there that this was a foreseeable common event?
The surveillance tape, I believe, speaks to itself that the dance was crowded. Mr. Dawson was colliding into other individuals prior to toppling on top of my client. And again, it is our position that while Ms. Spindler testified to having done other types of dancing, this particular event, they did not proactively ensure that there was safe seniors who were mismatched with these young 20-something students. There was no warning to them. There was no telling the individual youngsters to make sure to be a little more careful, having these elderly individuals on the dance floor. And it caused significant and serious injury to my client. And I mean, again, with Derry and the Court of Appeals, I mean, if we're going to go to foreseeability, I thought that was an excellent case here. The takeaway there, the exact manner of the accident or injury need not be predicted, only that an event would occur. And it is our belief that a predictable result of this inappropriate dance was an injury. It just so happened to be that my client was injured.
Okay. Thank you.
Thank you, Your Honors.
Your Honors, I'd just like to say that to accept plaintiff's position would be to hold that the Lenox Hill was an insurer of safety of people on its premises, and that's simply contrary to the well-established case law. And with respect to I can't say that for some reason, Derderian, the foreseeability in that case is discussing proximate cause. The breach and the duty have been established and presumed. In this case, it's a different level of analysis. We don't get to the proximate cause, although that is one of our arguments. There was no breach, there was no duty.
Is it your view that your client owed a duty to these people that was greater because they were all over 60 than they would have had if they were younger people?
Absolutely no, Your Honor. They were not senior citizens living on the premises, that there's no special relationship in this regard, and the courts are absolutely hesitant to impose the duty absent that special relationship unless it's, school, any kind of child and supervisor situation, elderly living on the premises. These independent individuals who were self-sufficient, who were walking independently, showed up to the center.
I don't understand, but they knew that this program was going on because your clients consistently hosted such a program, invited people onto the premises to participate in that program. And I guess I've looked at the video as well, and it's clearly identifiable as to which person is going to maybe lose their footing based upon their dancing. Why isn't there something there that would at least create this question?
Your Honor, if it were determined that there was a duty from the standpoint of just the premises owner, then we get to our point on the issue of foreseeability. And it was unforeseeable that the situation would occur based on the prior experience, based on the manner of music, and based on what was observable at the time of the occurrence. Unless the bench has any further questions, I'll rest on my brief.
Okay.
Thank you.
Thank you. Thank you both, counsel. The next case for argument is 938 St. Nicholas Avenue.
Good afternoon, Your Honors. Excuse me. May it please the court, my name is Greg Friedman of Kristen Feuerstein for the plaintiff appellant, 938 St. Nicholas Avenue lender. The lower court didn't...
Summary judgment was denied. If we were to affirm, what happens next in the case?
If you were to affirm...
If we were to affirm, what happens to your case going forward?
Well,
You'd then have a trial in which you would be trying to establish the standing issues that Judge Kahn found you had a problem with? Is that?
Well, the procedural posture now is that pending before the court, there is we engage in discovery, and there's a respondent filed their own summary judgment motion, and appellant cross moved for summary judgment, which we think corrected a lot of some of the deficiencies that the court sua sponte found on its own.
I mean, these were documents. The problem that Judge Kahn found, or at least some of the problems that Judge Kahn found, were that the affirmations that you submitted in support of this motion for summary judgment did not include some of the documents that were attached to them when they were provided to the court when Judge Madden had the case. And although she found that it was okay, at least to the extent you had produced documents from some of the earlier transfers, that case is not collateral estoppel, and therefore you really had to start all over again and give every piece of every document attached appropriately with the allonges and whatever on each one of the transfers to this judge, and that was the part of the problem the judge found.
I think part of the problem that this judge found was that he said that these documents were not, well, with respect to the 2014 Rudolph affidavit.
Yes, right.
So he said that those documents were not annexed to the affidavit, but the case law especially cited by the court in Kirschenbaum, none of the cases say that they have to be necessarily annexed directly to that affidavit. Those same documents were submitted. It's the term is submitted. Those same documents were actually submitted in this case.
They were in the record.
They were in the record. They were submitted.
But
The
they weren't
payment
submitted
records
as
were.
part of the prima facie case, right?
I'm sorry.
They weren't submitted on the prima facie case, right? On your client's motion for summary
No,
judgment.
they were. They were. As a whole, all those documents were submitted. The note that was referenced in the 2014 affidavit, Rudolph affidavit, the note was submitted. It was submitted, and it was submitted with the complaint, the verified complaint as well. Same exact note. And the mortgage reference therein, that was submitted with the
But were they
affidavit.
identified by an affidavit? Were they identified by an affidavit?
They were identified in the 2014 affidavit.
Okay, but
And those
that was
same
not the-
documents
excuse me.
were submitted.
2014 affidavit was not in front of this court as part of your prima facie case for summary judgment here, right?
No, it was. We put it in front of this court as well. It was part of the one of the affidavits that was submitted in support of our motion.
When you submitted everything that had come in before, you resubmitted on this case.
Correct. We submitted because we needed to show that, it was summary judgment was granted initially in the prior case, but then it was removed, it was overturned because of 1303 deficiency.
The notices.
The note, mortgage, and the default were all there. So all those documents were included in what we filed with our initial summary
The
judgment.
defendant didn't do anything in response to that prior order, which went in your favor before it was subsequently vacated or reversed because of your failure to comply with the notice requirement of the Real Property Actions and Proceedings Law, right? I mean, Judge Madden found in your favor on the previously, and there was no notice of appeal filed from that.
No. But
But nevertheless, that case is dismissed, so it doesn't really get collateral estoppel treatment, does it?
perhaps, not the summary judgment. I'm talking about specifically the substitution order. The substitution order, that issue was vigorously opposed, never appealed. And there the court held that, Judge Madden held in the substitution order that the appellant here, not any of its predecessors in interest, had a valid assignment.
But the substitution order was in the prior case, which did not result in a final judgment. So it's not entitled to collateral estoppel or res judicata effect.
Well, it was, with collateral estoppel, if it's decisive of the issue and the other side had a full and fair opportunity to contest it, and it's appealable, which all of those were, then it is collateral estoppel, Your Honor. So coupled with the fact that the substitution order held that that appellant received a valid assignment, that coupled with the verified complaint that confirmed as of the commencement of the action that appellant continued to be the owner and holder of the mortgage, these things together clearly established.
Your time is up. Let me quickly ask you a question.
Sure.
So it seems that Judge Kahn decides against you based upon issues with your prima facie case, which are not raised by the defendant, but the issues that Judge Kahn finds when you really dig into the record that's in front of the court, the documents that he finds wanting were actually present in the record?
They were all present in the record, Your Honor. The 2014 affidavit was there. If you want to discount that, the 2020 Rudolph affidavit was there with the payment history, showing the default.
Counsel, you're asking us to give collateral estoppel effect to the substitution order. Why would that be necessary if you'd actually submitted all of the documents that were submitted the first time around?
I'm sorry, I don't.
You're asking us to
talking
give
about collateral estoppel.
Excuse me.
Wait.
You're asking us to give collateral estoppel effect to the substitution order. Why would that be necessary if you'd actually put into the record and authenticated them properly all of the documents which were before the court at the time it issued the substitution order?
Well, I think all the documents were properly authenticated, Your Honor. That's an additional
Your
argument.
point that this is an alternative grounds.
Correct, Your Honor.
Okay, let's hear from the respondent, and you'll have a few moments to respond to that. Thank you.
Good afternoon, Your Honors, and may it please the court. My name is Erica Healy-Kagan, and I appear on behalf of the respondent, the Cliffcrest Housing Development Fund Corporation.
So when Judge Madden holds against you previously on the issues which are present in front of us now, and you don't appeal from that order, what's the justification for allowing you to relitigate those determinations? Your failure to file a notice of appeal, didn't that mean you accepted what Judge Madden had done on those issues?
No, Your Honor, and the prior summary judgment motion before Justice Madden was an entirely different plaintiff's predecessor. And so that is not relevant to the matter here. The substitution order that Your Honors also asked about, that was raised for the first time on this appeal. That was not raised before Justice Kahn below, so it really is not before Your Honors. However, it also dealt with different evidence. There's very different evidence and different questions of fact that have been raised in this matter that were not raised before Justice Madden, because in that case, discovery had not even really begun. And then Justice Madden dismissed that case, and in this case, there has been some discovery, and so there are different questions of fact, a number of questions of fact regarding whether the loan even funded, whether the loan was transferred with the required appertenant documents. This loan really has been traded between numerous entities in the secondary, subprime debt market over a period of 2 decades. So there are a lot of questions.
Did Judge Kahn, I don't remember, did he talk about in this decision whether or not the loan was funded? Was that part of this decision that's on appeal now?
No, Your Honor, and I apologize.
Because this decision seems to really be, he looked at all the documents and said, you produced the 2014 affidavit from Ms. Rudolph, but that had referred, when it was originally submitted, I guess in 2014, with another affirmation called the Slama affirmation, and that had some documents, and altogether that was sufficient. But now he said, I don't think the way it was submitted was sufficient. The other side seems to indicate that all those documents are in the record, they just weren't actually together. Is that a reason not to, should the judge have searched the record and granted them summary judgment? And if not, why?
Sure, Your Honor. The answer is no, and it's because summary judgment is a drastic remedy. Plaintiffs have accused Justice Kahn of being too granular, but it's exactly that level of particularity that's required, not to search the record, but to review the evidence before him.
Particularly in a foreclosure case.
Correct. And this is to prevent any issues of fraud, which is exactly one of defendants' claims in this case. So it's exactly being granular and particular that is required if we're going to...
There's an order on December 19, 2017 by Judge Madden, right?
Which order, Your Honor?
December 19, 2017, right? Correct. Granting summary judgment.
Your Honor, there were issues of summary judgment. However, they never became final because Justice Madden dismissed that case. Plaintiff's predecessor...
For different reasons.
Correct.
And you didn't put in a notice of appeal from that decision.
But that decision was vitiated by her dismissing the case. And actually, plaintiff's predecessor tried to appeal that.
Speaking generally, if there's a decision that decides an issue contrary to your position, and you have an opportunity to file a notice of appeal, are you free to just, and then subsequently the decision is for different reasons vacated, are you allowed to just, is it without any effect your failure to put in a notice of appeal from the order?
No, that's not our position, Your Honor, but that was plaintiff's predecessor in that case. So that is not the same evidence and issues that are before Justice Kahn now. It has completely been vitiated by both the change in circumstances, the change of evidence, and the fact that that case was dismissed. So Justice Madden's decisions...
Justice Madden didn't substitute this appellant into the case at that time?
That had not happened
On December 18th, 2017? She didn't sign an order substituting this appellant in the case?
That was one of her decisions, but that was not part of the summary judgment decision. And again,
and then the next day she signed an order granting summary judgment.
And then she vitiated that decision, Your Honor. And so...
for different reasons.
Yes, but the case was dismissed, and this court upheld the fact that that summary judgment order was not binding on the court, and in fact had been fully and finally vitiated by the dismissal of the case. I see my time is up, so if there are no other questions. Thank you, Your Honor.
Okay, thank you, counsel.
Your Honors, I'd just like to point out that counsel is absolutely incorrect regarding the substitution order. The substitution order speaks for itself. It substituted, Justice Madden substituted in this appellant in that case. And it's right there in the substitution order. It's in black and white. And I'd just like to point out that...
But subsequent to that, so there was a traverse hearing held, and as a result of that traverse hearing, the complaint was dismissed. After that, there was an appeal, because I was on it, there was an appeal in 2019 of a prior decision, and we said, even though there's been a traverse hearing, we still are going to make a decision here. But did that have to do with lender as the plaintiff, or was there...
I don't know. I can't speak to what happened on that appeal. I'm sorry. I'd just like to point out that none of the issues that Judge Kahn found with admissibility, attachment of the allonges, the deficiency, any purported deficiencies in the affidavit, none of that was raised by the defendant in their papers. This was all sua sponte by the court.
And had it been raised by the respondent in their papers, what would the difference be?
Well, we would have gotten a chance to reply. We had no opportunity to put in any kind of opposition to address these issues. And in the very same case...
But you're saying, had it been raised, the documents that would have answered the points raised were already in the record, and you could have, in reply, pointed the court to those documents.
We could have either pointed the court to those documents, or the court took issue with the nature of how the allonges were affixed. Even though all the cases, no cases say that it's a requirement to show standing to say that they have the nature of how they're attached,
Counsel,
just that they're firmly affixed.
If you believe that Justice Kahn overlooked documents which were in the record, why wasn't there a motion to re-argue?
There was a motion to re-argue. It was denied. I just want to leave you with this, Your Honors. In the very same case that Justice Kahn cited, Bank of New York versus Gordon, the same case cited by the lower court, the court stated, as a general matter, a court should not examine the admissibility of evidence submitted in support of a motion for summary judgment unless the non-moving party has specifically raised the issue in its opposition to the motion. For we are not in the business of blindsiding litigants. None of the issues raised by Judge Kahn in his decision were raised by the respondent. Thank you, Your Honors.
Okay, thank you. Thank you both. Moon 170 versus Bella. Good afternoon, you may begin.
Good afternoon, Your Honors. May it please the court, my name is Jonathan Schwartzman. I'm here for the appellant, Moon 170 Mercer. Your Honors, in 2017, this court awarded Moon a judgment In 2019, this court vacated that judgment, not because the judgment was improper, not because the court had not already affirmed liability literally 10 years ago, but to provide the guarantor respondent with an opportunity to prove the facts and circumstances of the eviction somehow prevented him from exercising his rights under his guarantee. And that was respondent's burden to show.
Why when the premises were relet on May 1st, 2013, weren't they?
I'm sorry, say again, Judge?
Weren't the premises re-rented on May 1st, 2013?
No, Judge, and that was dealt with by this court in the 2017 decision of the court which awarded Moon a judgment when the court held that the principal of Moon explained that they tried to relet the premises, but those efforts failed and there was no money collected. There's never been an allegation that rent was collected that wasn't credited to the respondent.
So what happened on May 1st?
Nothing. They tried to rent it out and it didn't work. And that's the court.
Who did they try to rent it to?
At that point, I believe they were going to try and rent it to a restaurant, but
Wasn't there a jewelry company that took over for a while?
I'm sorry?
A jewelry company?
That's Shambhala Jewels.
Yes,
That happens in September of 2017. We don't seek damages for that.
But in 2013, doesn't Shah try to take it over to put a restaurant in there himself?
Correct, and he does. And this court has already addressed that issue, and it's already been decided.
Shah is a principal in plaintiff, is he not?
He is, Judge. But what happened is this court has already dealt with that. That's been fully briefed. This is an issue that the guarantor is trying to raise again. That was not what this court remanded this for. This court remanded the case after deciding that Moon had liability. We've had that since December of 2013. It was affirmed by this court in November of 2014. In 2017, this court found that Moon had stated its damages, and they've never disputed damages. In fact, if you look at page 804 of the record, the respondent will actually cite to Moon's ledger of rent as being accurate. He's confirming our damages. His defense, as allowed by this court, was supposed to be he was going to show how the eviction prevented him from exercising his rights under the guarantee, and that never happens.
So you already have received $1 million from them.
$1.3 million paid by a bonding company, Your Honor, only after I went back to the Supreme Court to force the bonding company.
So that covered what period of time?
That covered through December 15th of 2015. The money we seek now is
Now you want another $800,000.
correct, and that's from January 1 of 2016 to September of 2017, and that is set forth chapter and verse in our damages calculation in the record. And again, the respondent relies on that.
So let me ask you, how does the whole finding about the problem with the effectiveness of the warrant play into this?
Judge.
I mean, there is the warrant was issued in 2011 and was not executed upon until 2013. Is that right?
That's correct, Your Honor, and that warrant is valid, and here's how we know.
But has it been proven? I mean, I thought that there was, again, this also has lots of appeals, some of which I've been on, but wasn't there a finding that there might be a question about the validity of that warrant that never seems to have been determined yet?
It hasn't been determined, and here's where it's determined.
So if it hasn't been determined, then
right
how can you recover on the guarantee until it's determined as to whether the validity of the warranty? So
Because we're here right now with the undisputed facts in this record showing that the tenant made a judicial admission in its pleadings before the court that you need to execute on that warrant. When Moon filed the 2012 holdover proceeding, the tenant said, as a matter of law, you cannot be here you need to execute on the warrant from the March 2012 stipulation. It's in the record. They were going to move, and this is undisputed in the record. Allison Furman, the lawyer who litigated this, put in an affidavit, and she says that they withdrew the 2012 petition to get a new warrant because the tenant, represented by some of the finest counsel in New York, Rosenberg and Estes, goes, you have to go back to that 2012 stipulation. And the 2012 stipulation holds, it reads, it's an agreement between the parties that if you don't pay your rent, they can execute on that warrant on a service or marshal's notice. And we know there's a marshal's notice because the respondent testified. But, Your Honors, the reality here is, may I just finish my point?
Sure.
The reality is, the respondent says, I could never execute on my guarantee because I could never have my friend, the tenant, turn in the keys. And from 2010, when he is first sued on his guarantee, he doesn't offer a single penny to the landlord to pay any arrears, even though he is told multiple times how much is owed, and he testified specifically. He admits that no one prevented him from paying the landlord.
Okay, let's hear from your adversary, and you'll have a couple minutes to respond. Thank you.
Good afternoon. David Wolf for the respondent, Zachary Vella. It's good to see everybody again for our fifth time up here.
Lovely to have
answer
you.
the court's question.
Can you follow up from what we were talking about with counsel? I have a copy of this stipulation from 2012.
Mm-hmm.
What effect does that stipulation have on any of the issues that are before us today?
The stipulation from 2012 was in the record when this court reinstated the tenant's cause of action for wrongful eviction and said that the facts arguably show that the landlord revived the tenancy, which of course we all know has the effect of invalidating the warrant and then making the eviction illegal. It was also in the record when this court vacated the judgment and said that Mr. Vella should have the opportunity to go back and demonstrate the way in which the secret execution of the warrant prevented him from exercising the limitation on his personal liability. So the existence of that stipulation doesn't resolve anything. We have an open question. Was the warrant of eviction invalid? Did the landlord revive the tenancy? They've never established that they did. Quite the contrary, their words and actions show that they did in fact revive the tenancy. And before I get into that, specifically what it says in the March 9, 2012 stipulation is it says that the warrant of eviction will be stayed until March 2nd, 2012, which had already happened, obviously. So that really raises more questions than it answers. It also says that the tenant had already given the landlord 5 post-dated checks aggregating to $25,000. And it says if those checks clear, then the landlord accepts the $25,000 in full satisfaction of all claims in this proceeding, the original holdover proceeding. We know for a fact that the checks did clear, because if we look at record page 758, it's the landlord's own ledger, and you see a grouping of checks at the end of February of 2012 and beginning of March 2012, totaling $25,000. So that's full satisfaction of all the claims brought in the first proceeding. Then they continue to collect rent. They continue to invoice for rent. When the tenant allegedly stops paying it another year later, the landlord doesn't execute on the warrant of eviction. I'm sorry, it wasn't another year later. It was a month later. It was in April of 2012. They serve a notice to cure saying the lease is in effect. They start a petition with a new termination date, which means the lease was in effect. They then stipulate they accept a payment to end that case. They start this lawsuit using the present tense, landlord is the landlord, tenant is the tenant, clearly evincing their understanding that the lease had been put back into effect.
Why is there still a question as to whether or not the lease was revived between the time of its issuance in 2011 and the time of its execution 2 years later in 2013. That's what Judge Ostrager found. Like it's a long time. We haven't figured that out yet.
Your Honor, I believe we have. I believe we've clearly shown that the tenancy was reinstated. This is what the landlord itself said by its actions and
So
by
if we were to affirm Judge Ostrager's decision, would you have to go back for a trial on the validity of that warrant of eviction? Is that one of the issues you would have to try?
Yes, Your Honor, it's the highlight issue. There are other issues, but that would be tried, and we would prove it by showing the landlord's own words from January of 2013 in the contract saying the lease is in full force and effect. Everything the landlord said and did shows that it reinstated the lease. It reinstated the tenancy, and the warrant of eviction was invalid, which makes the eviction illegal.
And so when you paid $1 million under the guarantee, that covered what, for what period of time?
That covered all of the rent that had accrued up until December 15 of 2015.
Even though you're still questioning the validity of the warrant from before that?
Our motion for summary judgment was denied and the landlord's was granted in large part because at that time, I shouldn't say in large part, because at that time, the tenant's cause of action for wrongful eviction had been dismissed on a 3211 motion. And then after that happens, this court reversed the dismissal, reinstated the cause of action. We then moved and have been in the process since then of pursuing that particular defense in this case. And we will establish it at trial, assuming that the order is affirmed as it should be. Frankly, if anything is modified, it should be to search the record and grant it in our favor. But we didn't appeal, and we understand we're going to go.
Yes, so what other issue other than that would be tried, other than the validity of the warrant of eviction from 10 years ago?
As Justice Ostrager points out, there's a question as to the quantum of damages, if any. So looking past all of the facts demonstrating that the landlord wrongfully evicted the tenant, if the court were to grant them a judgment for some reason that I can't even foresee at this point, but there would be, if I may finish with this point, there would be issues of facts as to the amount. There was a lot of wordplay here about when things happened and how much is owed. You know, again, if the court looks at the landlord's own ledger, which we're not endorsing, we've never said it's accurate, but we've only pointed it to say this is what they say is owed. If the court looks to the landlord's own ledger, on May 1, 2017, the date that I believe Justice Friedman was asking about when the Shambhala lease was signed, on May 1, 2017, landlord's own records show that the amount of rent owed was $236,000. They're asking for $800,000, which is a heck of a lot more, and that's all rent that accrued after the Shambhala lease. They're certainly not entitled to that. There's issues of fact. We heard Counsel here say today that we did in fact receive the notice of eviction, but we didn't. That's an issue of fact. There are many issues of fact, and none of them have been cleared up. The motion by plaintiff was properly denied. Thank you, Your Honor.
Okay, thank you. Counsel, you have 2 minutes.
Your Honors, briefly, if you look at page 134 and 135 of the record, you'll see the answer of the tenant, which in which the tenant swears in open court that you have to go and execute on the warrant under the stipulation, and the warrant under the stipulation has to be valid then. Nothing invalidated it. That's in August of 2012. But Judge, we also have a settlement agreement whereby the tenant has agreed that it owes the rent. So what you have is a guarantor trying to commandeer an action of the tenant, which, by the way, the tenant was strong-armed into bringing this action. The record shows that the respondent threatened the tenant's mother with a lawsuit if they didn't bring this action. They underwrote that lawsuit. It's all in the record. It's all cited in our brief. They forced this issue, and once the judgment was paid, the tenant settled by just walking away from its claims because they were never real claims. It wasn't a real claim. The guarantor admitted that he had the tenant bring the wrongful eviction claim solely as a defense to this action. That's why they brought it.
But it seems to me, I've tried to read as much as I could here, but it seemed of the record, but it seems to me that the issue of the validity of that warrant somehow has still not been resolved.
It has, Judge. On the record before you right now, you have Allison Furman, the only person with personal knowledge, because the guarantor doesn't have personal knowledge. He admits that in his deposition. He has no knowledge of what happened. Allison Furman does. They went back to that warrant because the parties agreed. The tenant agreed and the landlord agreed. They would go back to the March 9th stip, which holds you can execute the warrant on the service of a marshal's notice. And we know there's a marshal's notice because the respondent testifies specifically that he knows. His words are, I definitely know there was one. Moon didn't do anything wrong here. Moon is simply trying to collect the rent that he guaranteed. Judge, at the end of the day, the respondent's a very wealthy guy. He's been in real estate for 20 years. He's leased millions of square feet. This is all his language. He's worth $150 million. He writes that to the court. He knows what he's doing. He bet on his friend's business. He guaranteed his friend's business. It failed. He just doesn't want to pay the piper. What he wants to do is get to a trial. Why? Because it's 10 years later. He's betting that Moon can't prove its damages because memories fade, maybe documents are lost. I don't think so. But maybe he's hoping that he knows he's done nothing to exercise his guarantee. He's done nothing. And what he's going to try and do is shift that burden back to Moon. You can't find your witnesses. You can't prove your damages. This is bad faith litigation tactic.
Well, thank you very much. We'll go back and see if we can figure this out. Have a nice afternoon. Okay, the next case for argument is Citizen Watch versus Zapco. Good afternoon.
Good afternoon. Glenn Kaminsky with Thermomedy, Demers McManus, counsel for the appellant. Respectfully here asking the court to reverse the judgment of the Supreme Court. My argument here is very, very simple. The Supreme Court abused its discretion in issuing the ultimate sanction here, despite a record which shows good faith efforts to provide all discovery, all relevant documents in Zepco's possession.
Well, there was a conditional order here that the court found that you had not complied with, and conditional orders are difficult. But I mean, were you able to show Judge Maisley that in fact you had complied with her conditional order?
I think that the response to the order that's dated February 9th, 2021, at 8:37 of the record, shows that there is a response, a proper and full response to the order. And let's remember, that interim order was not an order that granted the ultimate sanction. Right? There were papers thereafter that had to be determined. Matter of fact,
the interim order is dated what? Which order are you talking about?
Well, the interim order, the first order.
I have an interim order that's dated January 14th, 2022, and it says, plaintiff's motion to strike defendant's answer will be granted unless defendant complies with plaintiff's outstanding request, including, and then she goes through the different things.
Right. Well, she does say it will be granted, but then if you look at 823 of the record, where we're in the transcript and we're actually arguing the motion, and the counsel says that a motion to strike, and she said that's not happening. And so when you read that, it says will be granted. It doesn't say it was granted unless you comply with this. All right. There were subsequent papers So we didn't have to show a reasonable.
Just going back, even before the conditional order, there had been a PC conference back in May of 2021. The conditional order strike is not issued until January 14th, 2022. I mean, that's a couple of months later, where you had not raised any objections to what was what stemmed from that PC conference. And even in September of 2021, there had been a stipulation that you would produce further documents. And then we have this conditional order wherein the court, in their discretion, found that that you hadn't produced the documents that you even agreed to produce. So why isn't that entitled to some sort of deference?
Well, I think when you look at this, all right, so you have the preliminary conference order, which is 3 months after our firm appeared, and after a considerable amount of time where they were trying to negotiate a resolution to the case. We responded July 28th of 2021, providing significant documents.
That was still 27 days late from the date you were supposed to respond.
But even late disclosures will not be found to be willful and contumacious here. And you can see with the letters and the emails, the efforts being made, the November 9th letter, where we invite them to take the deposition for the purposes of discovery.
Does it have to be a willful and contumacious non-response if there's a conditional order that there'll be dismissal if the discovery is not provided?
Yes, it is an abuse of discretion standard if it is a willful. There needs to be a clear showing, not just a showing, a clear showing of willful and contumacious proceedings. And that doesn't exist here.
Even if there's a conditional order of dismissal?
Even if you consider a conditional, I don't consider it a conditional order of dismissal because I read it, it says it will be dismissed in the future, and combine that at 823 of the record where the court says, I'm not striking it right now. But even if you do, we do have a reasonable excuse. We do have a meritorious defense. We show that throughout the record. We see that the discovery that has been provided, the March 21st letter at 9:04 of the record, the November 9th, 2021 at 5:41 of the record, shows reasonable efforts, reasonable excuse to get this all done. 2 Jackson affidavits. We see that there is a lease modification. We see that there's disclosure and an admission by plaintiff at page 5 of his brief, citing to page 35 of the record that says that the roof had been replaced.
Okay.
All of this shows a meritorious defense.
Okay.
This is not the kind of case to throw us out for the ultimate sanction.
Okay, we'll hear from the respondent. You'll have a moment to respond to him.
May it please the court, my name is Arthur Rosenberg from the firm of King Kessler on behalf of the respondent, Citizen Watch Company of America. I agree with counsel. This is a matter having to do with was there an abuse of discretion. Specifically, in this case, did Judge Maisley abuse her discretion in finding that the numerous deficiencies of the defendant appellant with regard to their discovery obligations warranted striking of defendant's answer? And the answer is no, there was no abuse of discretion. There was there was replete in the record of various and several instances of the defendant's failure to comply and to meet its obligations. As my opponent said just a few moments ago, there's an issue of willfulness, and to direct the question that was directed by Justice Friedman, in fact, willfulness is not an issue when there's been a conditional order. And while counsel says he doesn't consider Judge Maisley's January 14, 2022 order to be conditional, in fact, by its own specific language, as stated in the record, as Justice Kapnick noted, it was a conditional order.
But after that conditional order was was issued, the defendant raised objections. It's not as if they completely ignored it. They raised objections to what was inside that conditional order. Why isn't that sufficient?
Well, I don't think they raised objections. They responded. They attempted to respond to that conditional order by providing a response on February 9th, which the court found, after considering all the various submissions, because we were allowed an opportunity to respond, and the court granted even a further response by the appellant. And the court ultimately found in her July 4th, 2022 decision that attempted response was woefully inadequate, and that the submissions by the appellant of affidavits, purported Jackson affidavits, and as the court cites in her decision, completely were insufficient, failed to comply with any of the standards or requirements of a Jackson affidavit, and failed to adequately explain. And in fact, just to address the issue of willfulness, the Court of Appeals, more than a decade ago in Gibbs, which we cite in our case, specifically, which is a case right on point here, specifically talks about when a party fails to comply with discovery and a conditional order is issued, and there is a failure to comply with that conditional order, then willfulness is no longer to be considered. That conditional order becomes absolute, and that's exactly what happened in this case. And then the Gibbs goes on to say that in order to cure that default, the offending party must show a reasonable explanation and a meritorious defense. Well, the reasonable explanation essentially was these failed Jackson affidavits, which the court found and made factual findings in her July 4th decision that specifically said that it was insufficient. Those attempts were insufficient, didn't meet the Jackson requirements, and didn't address the issues. So that reasonable explanation prong was not met, and they must show a meritorious defense. And in fact, nowhere in their papers, in their underlying motion papers, or in their briefs, does appellant address the merits of this case or of the defense. It's nowhere to be found. So that completely fails in that regard. And finally, with regard to willfulness, even if Gibbs didn't apply, which we argue that it does, the record shows that the conduct of the appellant here was willful, was intentional. This was a sophisticated party owning hundreds of millions of dollars in a building. They knew what they needed to do, and they failed miserably to provide the evidence that they had, or should have preserved, and failed to produce.
Counsel, how much time was this defendant allotted to provide this discovery that had been requested? How much time from the initial discovery demand until they partially produced something?
To give you the specific timeline, Your Honor, it was ultimately more than a year. Initial requests, document demands, and interrogatories were served by the plaintiff in January of 2021. There was a PC order in May of 21. They were required to respond by the end of June, which they didn't respond to until the end of July. There was then a meet and confer in September, where there was a stipulation where appellant agreed to provide the requested material without objection, never made an objection to anything, agreed to provide the material within, I think, about 2 weeks. They then couldn't comply with that. They asked for additional time. We gave them additional time until the end of October. They missed that deadline. Finally, in November, they produced a few amount of documents and said, we just learned from our client we have a trove of documents that we need to go through. We then made our motion by order to show cause. That motion was returnable in January of 2022. At that point, the court found that they had not complied, issued the conditional order, gave them an additional 30 days to February, to mid-February to respond, to produce the material. And it was at that time, and then, in fact, we had an opportunity, the judge asked us, Judge Maisley asked us to be able to respond as to their sufficiency of their compliance. We noted that, and they then yet requested additional time until the end of March of 2022, 14 months after, when they finally produced the affidavits that were, that the court then found 3 months later to be insufficient. And by the way, to answer your question, between the end of March, when the final submission, until the court issued its decision in July, those 3 months, nothing came forward, nothing else was produced, no attempt to correct the obviously deficient affidavits or any further discovery. So they never complied.
Oh,
Thank you.
okay, thank you.
Thank you.
Looking at some of the documents, materials that they were asked to produce, that we were asked to produce, there's the constant complaint by the plaintiff that the custodians of documents were not disclosed.
Well,
Plaintiff does not advise. This
part of the problem I'm having, at least, is that there is this somewhat extensive 4-page typewritten stipulation that was entered into between the parties in September, at the end of September 2021, saying that you were going to produce all these documents by October 14th, 2021. And the order that you're appealing from Judge Maisley didn't come out until, the following August. So there was a lot of time there. I mean, why didn't you produce these documents you agreed to?
They were responded to that. Look, can we say that no sanction is applicable? No, I'm not saying that. I'm saying time elapsed. We cost them money. But that's the only prejudice alleged in this whole thing is money. Money and time. Nothing else. Nothing about the substantive issues in this case. And that's what I'm just about to tell you about the custodians of the record. It's constantly said, they didn't provide the custodians of the record. The custodians they refer to are all employed by CBRE, not by our client. It raises the question, why didn't they subpoena the records? There were other avenues for this disclosure. I'm referring to you to refer you to 548 of the record with regard to Finley and Bakori, 101 of the record for Kehoe and Catano. By the way, people we did disclose at 101 and 103 of the record in July of 2021, even though they weren't employed by us. So a look at this record as a whole. I'm not saying we're saints. I'm not saying we did everything perfectly. But we did not act willfully and contumacious. The November 9th, 2021 letter shows that.
Okay.
Everything shows that, Your Honors. And there was a reasonable excuse and meritorious defense demonstrated throughout.
Okay, we will certainly take a look at this. Thank you. Thank you both. The next case for argument is Perfectly Reliable against 213 East 26th. Good afternoon, counsel.
Good afternoon, Your Honors. My name is Scott Benjamin from the law offices of Andreas Vassilatos. I represent the defendants' appellants in this matter. As you know, this is an appeal from a judgment after trial. And I think the first and easiest point that I want to address is that the judgment imposed joint and several liability against all of the defendants when, in fact, there was no indication that the defendants had overlapping liability for the others.
That was never really raised in the trial, was it? There was no claim of that?
In fact, very much the opposite was raised during the trial, because we argued that several of the entities and the individual defendants, Mr. and Mrs. Krollman, we argued that they had no, there was no piercing of the corporate veil such as to impose individual liability on them.
Well,
that was granted.
That certainly seems to be a point which has some substance to it, but the remedy for that would be to modify the judgment to bifurcate what's awarded to whom.
Right. I'm just saying that's, it shows, I think, frankly.
That's not your main concern, I
That's
don't
not my main concern, but it does show, I think, the lax casualness with which the court below handled some of the evidentiary rulings. The key concern, I think, are that our argument is that the contracts that were introduced into evidence never should have been admitted into evidence, as well as a document which was identified
Well,
as
I know they. Go ahead.
identify,
I mean, I know they weren't signed.
right.
I mean, everybody knew they weren't signed, but nobody really said, oh, well, I don't know why they came and did work for us. They're such nice people. They came and we don't know them. That wasn't the claim, and there was certainly a relationship.
There was certainly a relationship, and there was certainly work done. However, it's important to recognize that the complaint was not framed on a quantum merit basis, that we did some work and we should be paid the fair value of
I
it.
understand.
That could have been a legitimate claim. They did not raise that.
But wasn't their argument really that the contracts were ratified by the course of conduct? That the work they did was reflected what was in the contracts, and your partial payments to them were based on what was in the contract. So that really ratified.
That would also be consistent with the quantum merit theory, and I think
Right, but it's also consistent with a contract claim.
well, I think what makes that problematic here is that all of the contracts weren't signed, but the principal of the plaintiff, Mr. Sundee Lee, he testified that at a point there were signed copies of the contract, but he didn't know where they went.
Well, I thought he sort of disputed that. I mean, in terms of, I know you said that you thought he said that at some point in his deposition, and I thought it was, it wasn't exactly what he said, and I think
Gave that testimony at a
he isn't-
deposition.
he isn't fluent in
He's not fluent in English, and I think you could see in the trial testimony, it was a little bit tricky because of the interpreter.
Virtually, it makes it even harder.
Right, so there was some mechanical
Both
issues.
sides have the same unsigned contract, and there isn't any evidence other than this somewhat less than clear statement from the plaintiff's principal that the contract was actually signed.
Well, what I think is critical is that the witness, Mr. Lee, he doesn't speak or read English, certainly not adequately enough to read or understand the
If
contract.
the unsigned contract was ratified, does it matter whether it was signed or not?
I think it does, because you would need to establish that the unsigned contract, the one that was introduced into evidence, is the same as the signed one that was lost or left at home somewhere else. Clearly, something about those contracts indicates that they were at best in a draft state. So if there was a contract that leaves blank the name of the entities that were supposed to do the work, that suggests that those...
Who prepared those contracts?
I'm sorry?
Who prepared those
I
contracts?
believe those contracts were prepared by the defendant appellants. But...
They were prepared by you.
Right, but as those
You
contracts
haven't
are...
come forward with anything which varies what was presented at trial. You don't come forward and say, look,
That's
not the
true.
contract. This is our contract.
Right, I appreciate that, and that's true, but it is plaintiff's burden to establish what the contractual obligation was, and one of the obligations, there's a case I cite in the brief called Shozer that says that where the original, the best evidence is not available, the proponent of that document has to give a reasonable reason why they're not there, and show, and the Shozer case uses the word heavy burden, has the heavy burden of showing that the replacement document is identical or a reasonable facsimile of what the original document was, and I don't think that was done. I would also like to address, though, the issue, I see my light coming on, the issue of Exhibit 19, which was the summary of the transactions. That also should never have been admitted into evidence, and the reason for that is that summary tables can be admissible, but only in cases where the raw data that produces the summary is available for inspection by all sides, including the court. Additionally, there is
Was there
no...
any serious dispute as to any of the numbers in Exhibit 19?
I'm sorry?
Was there any actual dispute as to the numbers in Exhibit 19?
Well, if the document shouldn't...
Counsel, could you answer my question? Was there any serious dispute as to the numbers in Exhibit 19?
Yes, I think there was, because part of it
How
is...
was that, how was it contested?
The amounts that are due, his claim, according to Exhibit 19, is that 100% of the work was done on most of the transactions that were involved. And I think one or two, there was less than 100% of the work done. We contest that. We don't believe that 100% of the work was done.
In what form did you contest the numbers in Exhibit 19?
By objecting to the introduction of that document,
Right.
and by introducing testimony on the defendant's case that various aspects of the work were not completed.
And wasn't that testimony presented by an individual who had not actually examined the work?
I don't believe that to be the case. I believe that individual had examined at least some of the work, was present when some of the work was done, and he gave testimony that the project was understaffed. which
Are you
resulted
talking
in
about what
delays.
Pesci did? Isn't it so that Pesci didn't personally inspect the work?
Right.
I believe he had at least seen photographs of the work and was aware of the staffing.
So basing it on photographs is not the same as personally examining it, right?
Well, Mr. Croman also had seen the work, and he testified to some of the inadequacies of it.
Okay, let's hear from the respondent. You'll have a couple minutes to reply. Thank you.
Good afternoon, Arnold DeJoseph for the plaintiff respondent. Let's deal with Pesci first. He says at 395, 396, he's never personally inspected this job site. So moving on to the contracts, if you read the record here, the plaintiff, Mr. Lee, says these are the contracts that were given me. He's able to read Arabic and English numbers. He testifies so to in the record. So the amounts, the apartment numbers, the addresses, some of the measure, whatever's in there, and it's prepared by the defendant. And the crazy part of this case is they are relying on these contracts for half of their defenses in this case. So the other thing is, if you look, and this came up in another appeal that Justice Pitt Burke was on last month, they supplied these contracts to the court as trial exhibits at page 64 of their pretrial order, and so did the plaintiff. Now, the way they did it, they just had the 4 addresses and said it was like one contract. But how are they coming with a straight face today and going, this shouldn't come into evidence? They prepared them. It's their contract numbers. They don't dispute the numbers.
Was there any definitive testimony, as counsel alleged, by your client, Mr. Lee, that in fact there had been signed contracts?
No, not to the extent you're saying, Your Honor, where we said, yes, there's a translation issue. Yes, this trial was terrible because it was during COVID and it was virtual when they first started to do them. So that part I agree with. As far as the graph, they just dance over the fact that it's prepared in the regular course of this company's business. And that they raise points in their brief that, well,
it was contemporaneously prepared,
Yes,
and Mr. Lee prepared it with his niece.
and there's a question, well, it was all done on one day, but it doesn't matter. It's done with the data supplied by him, which under the statute is okay to do. But the real part of this case is the defendants submitted no documentary proof whatsoever to support anything they ever testified to at the trial. In other words, they came to court and said, believe me, they didn't finish the work. The plaintiff didn't do this. The plaintiff didn't do that. He didn't get sign-offs. He didn't do this. He didn't comply with the work. Mr. Croman actually states, I have lost a fortune. He says that in the record, but doesn't supply one email, one document, one anything to back up any of his testimony, thus putting himself in the position of whether or not the judge in the court below believed the word that came out of his mouth. And it's clear the judge goes through this in his decision, that he evaluated the credibility of these witnesses, and he found the plaintiff to be credible. Didn't say anything bad about the defendants, but when you say one side is credible and you don't mention the other, you must accept the fact that he's not finding any of the defendant's testimony credible. And I say to you, it's because they just say whatever they want. This guy didn't do the work, I'm not paying him. And that's literally what these companies did. As far as the judgment, I addressed this in my brief, it's 100% right. It has to be modified. There was a little testimony, but nothing that you could say that they're joint and severally liable. What else do I want to go over with you? I just don't think there's anything here to attack the court below's discretion in how it decided this case. If you had this evidence about
Was there anybody that testified on behalf of the defendant that actually went to inspect the work? He said Mr. Croman saw some of the work, but
the testimony, look, they say to you, well, look at the contract. The sprinkler system for the carriage, they were converting
Carriage house, yes.
Carriage house and I think 200 Stanton. The sprinkler system. Read all those contracts. There's not one mention of a sprinkler system being put in, and what he testifies to is, I'm going to rely on the fact that it has to comply with the building code as to why that means there's a sprinkler system that had to be installed. Why is a kitchen faucet or fixtures in the contract, but a sprinkler system is not listed in there? Their testimony is incredible in this case, and the trial court was fully aware of it and listened to it and decided the case accordingly. And I don't have anything further, Your Honor.
Okay, thank you very much, counsel.
Thank you again, Your Honors, and I want to respond to a couple of points that my adversary made. One of which is that he says that our client, the defendant appellants, didn't produce any documents relating to the alleged deficiencies. Even if that was true, it's notable that in the court's decision after trial, the court found that that there were conditions precedent. In other words, these were all time is of the essence contracts, and the contracts were all conditioned upon obtaining sign-offs for plumbing and electrical work. The court, although the court found Mr. Lee credible, the court didn't specify what it found him credible about, because Mr. Lee never gave any explanation for what it was that caused the delays. Mr. Lee, in his testimony, acknowledged that I believe each and every one of the projects was late according to the time is of the essence schedule.
But wasn't there some change orders and requests made by the defendant, and that would support the reason why the project was late? And in fact, Mr. Pesci, he testified.
That's my point. The issue of the change orders, the contracts all specify the change orders had to be in writing, but no change orders in writing were introduced into evidence, and no change orders were even described by Mr. Lee.
But Mr. Pesci, he agreed that there were some changes and requests made by the defendant. And wouldn't that frustrate the purpose of the time of the essence? You're changing the orders. Your own witness testified to it.
There was not sufficient testimony about the nature of the alleged change orders that would give the court, or this court, an ability to understand the nature and scope of the changes such that the court could conclude that they reasonably caused the delay. In other words, if there was a change order that said, change the doorknobs from black to metallic colored, that wouldn't account for a many month delay in the completion of the project or in the obtaining of the sign-offs. So just as much as we may not have produced certain documentation, Mr. Lee, who had the burden of proof to show that arguably we were responsible for any delays, did not introduce anything, not even a description.
Okay, we will thank you both, counsel. We'll certainly take a look at the documents again.
Thank you for your time.
And the papers. Have a nice day. The next case for argument is People versus Angel Gomez. Good afternoon.
Good afternoon, and may it please the court. Danielle Bernstein from the Legal Aid Society, and I have the privilege of representing Mr. Angel Gomez today. Mr. Gomez is making a modest request of this court that it reduce his term of post-release supervision to the step.
Isn't his first request that we find that the appeal waiver is not valid? Because if it is valid, then we don't get to any of his other modest requests, right?
Absolutely, Your Honor, and that one is not a modest request in our view. This appeal waiver is rife with errors and inaccuracies, and there's a number of them that we outlined in our brief, but first and foremost, easily the most glaring, is the oral colloquy from the plea court suggesting that Mr. Gomez would not have any rights that he would retain after he entered into an appeal waiver that would withstand that waiver. The Court of Appeals has made it absolutely clear that the presentation to a defendant that a waiver operate as an absolute bar to appeal invalidates it. And it is a holistic review, but that in and of itself is enough, Your Honor, in our view.
Does the written waiver that he signed in any way fix that problem?
Not in this case, Your Honor, and for a few reasons. First of all, the written waiver repeats a critical error from the oral colloquy. In the oral colloquy, the plea court suggested that Mr. Gomez wouldn't retain the right to appointed counsel for purposes of his non-waived issues. And the written waiver repeats that. It reads, I understand that the right to appeal would have allowed me, with the assistance of attorney, to deal with all these appellate issues, and I'm waiving that as a condition of the plea. And so, at a minimum, that language is ambiguous as to whether the appointment of counsel would have survived, and so it's repeating, again, a fatal flaw from the oral colloquy. But in addition, It doesn't cure the oral colloquy because Mr. Gomez signed it before the oral colloquy. And sort of chronologically and logically speaking, how can something cure something that it precedes? You know, the last words that Mr. Gomez heard were the defective explanation of the plea court of what his rights were. And so in this particular instance, the written waiver really does nothing to fix this, this colloquy. And if there are no other questions about the appeal waiver, I would return to the equities, Your Honor. Your Honors. Returning to the modest request that Mr. Gomez is making as to the term of post-release supervision, there are numerous relevant mitigating factors here that point to why a more tailored term is appropriate in this case, beginning with the context of the crime. Mr. Gomez was 18 years old when this offense occurred. It had only been a year since his biological father had died of a drug overdose, but not before that same father introduced Mr. Gomez to his own drug dependency. And it had only been a few years since Mr. Gomez had been betrayed by his primary father figure, his stepfather, upon learning that his stepfather was sexually abusing his younger sister.
Isn't he currently awaiting trial on a charge of possessing stolen property in Westchester? Is that where he is now?
Your Honor, he is currently in custody in Westchester. I would note that the charges that happened after the fact of his sentencing are outside the record here, but even so, the courts in those cases, it's two cases from the same instance, Your Honor, in two different counties, will have the opportunity to impose an appropriate sentence in those cases. The question before this court is, when the sentencing court saw Mr. Gomez at 19 years old, a teenager, in light of all of the facts surrounding the context of this crime, and in light of his success previously in treatment, which post-release supervision does not provide, what would the appropriate term of supervision be for that 19-year-old after 3.5 years in custody, given his need for treatment and the changes to his psychology and the social science that reveals that a shorter term of post-release supervision tends to better help people reintegrate into society. And again, Mr. Gomez successfully completed drug and mental health counseling as a teenager. His caseworker at the Esperanza organization called him an open and active participant. He completed vocational training. When given the right tools, he has shown improvement. And that's why 2.5 years is really the upper limit of what will be appropriate for him in this instance. Post-release supervision will help give him structure. It will help him, reintegrate into society upon his release from custody, but it won't provide him with treatment. And that's, a significant difference here. There's a difference between being monitored, which is useful up to a point, and being treated. And the social science is incredibly clear that between a year and 18 months, and at most 2 years, is really the upper limit of what helps an individual get back.
Are you saying that if he's on post-release supervision, he can't go out and seek the treatment? What does one have to do with the other?
He certainly could, Your Honor. My point is that post-release supervision doesn't necessarily provide that to him. And so since it's a monitoring system, which is useful for, again, imposing structure in his life, that use starts to diminish after the 2.5-year term. And so that's the distinction that I'm making, Your Honor. And so, again, noting that this is someone who benefits from treatment, the benefits that one might attach to post-release supervision wouldn't necessarily attach here, especially after 2.5 years. Sorry, was there a question? No. Again, considering the nature of the offense, the nature of when he has most benefited.
Okay. Just finish your sentence. Go ahead.
Okay. Well, for those reasons, Your Honor, we ask that you reduce the sentence. Thank you.
Okay, we'll hear from the people, and you'll have a minute or two to respond, okay?
Good afternoon, Your Honors. May it please the court. Noah J. Sexton for the people. I'd like to open up by clarifying immediately, because in a way this upends the entire matter, as a matter of public record, that those felonies that you were talking about that he's being remanded for, he was just convicted on both of them of an E felony, grand larceny, by statute, especially as a predicate. He's going to prison for at least the next 1.5 to 3 years. This entire argument is academic at this point. It's certainly academic.
In the Westchester case.
In Westchester and the Bronx, he has been convicted. That renders most of this appeal academic. I mean, it certainly renders the excessive sentence argument academic, because he is saying he has an excessive, period of post-release supervision. By operation of law, he's not on post-release supervision anymore. That was merged into his sentence as soon as he was pronounced guilty. He hasn't been sentenced yet, but there is literally no way by law that he could have anything other than a prison sentence of at least 1.5 years. Now, speaking to, just very briefly, because I'm going to rest most of my argument on the merits, again, we're essentially, with all due respect to my adversary, having a conversation pondering intellectually a controversy that doesn't exist. The interests of justice do not favor reducing a period of post-release supervision in this case. You know, looking past the fact, okay, he was young, you know, he had a troubled home life, doesn't change the fact that he slashed a man's neck for the perceived slight of looking at him at a bus stop 7 months after he had been found guilty of robbery, his first violent felony offense. This does not change the fact that when he was in his pre-sentencing interview, he said that he had no underlying health issues. He said that he couldn't remember the last time he had been to counseling. He said that he couldn't remember the details of the actual programs that he was part of. Speaking very briefly to the waiver of the right to appeal, this was valid. The colloquy was fine. It adequately distinguished between trial rights and appellate rights. He was given poor person relief on appeal, which means he knew he had the right to that. And frankly, under your decision in People v. Diaz, May 2022, he's foreclosed from talking about a mandatory surcharge. If Your Honors have no further questions, we ask you affirm.
Thank you, counsel.
First of all, Your Honors, this is not an academic argument. If Mr. Gomez serves the lower end of the sentences that he is likely set to receive in those cases, there will still be remaining post-release supervision. It expires in May 2025 in this case. So it's not an intellectual exercise. It has a meaningful effect on Mr. Gomez's life. And I would briefly like to turn to the surcharge, if that's all right. First of all, it is our position that notwithstanding that this waiver is clearly invalid, even if it were valid, it would not apply to Mr. Gomez's surcharge because he couldn't have bargained away the right to something that didn't exist at the time that he was sentenced. And I would urge the court to consider a different set of factors as to the surcharge and the fees than is at play for the excessive sentence issue. Regardless of this court's position as to Mr. Gomez's sentence, the issue relative to the surcharge and fees is about the costs and the financial difficulties imposed not only on Mr. Gomez, who was a teenager, hadn't graduated high school, was not employed, was indigent, but also on his family. The pre-sentence report makes clear that Mr. Gomez was dependent on his mother for financial support, and he had two very young twin kids who were 2 years old at the time of his sentencing. And so the fees and costs here don't just go to Mr. Gomez, but also to a number of other people who will be affected by that. And that's exactly what the legislature was interested in amending the criminal procedure law, was ensuring that finances not only don't prevent defendants from getting back on the right path, but also don't inadvertently harm their families in the process. So again, as this court has done in similar cases, we request that you reduce his post-release supervision and for entirely separate reasons, vacate and remit the surcharge and fees. Thank you.
Thank you. Thank you both. The next case for argument is Hobish versus AXA Equitable. Good afternoon, counsel.
Good afternoon, Your Honors. May it please the Court, I'm Gary Malone, Constantine Cannon, representing appellant Richard Hobish. We are asking for the reversal of the motion court's rulings, which would permit AXA Insurance Company to keep the benefits from an unconscionable and inequitable rate hike that more than doubled the 91-year-old Mrs. Hobish's premiums as part of a bait-and-switch scheme to exploit elderly policyholders by pressuring them to either pay exorbitant premiums.
The policy was taken out in 2007, right?
Correct, Your Honor.
And there were no increases in premium until 2015, is that correct?
In 2015, they were announced to take place in 2016.
They were, right, and it's your contention that those premium increases went from something like 60,000 to something like 160,000. Is that correct?
For Mrs. Hobish.
Yeah.
And Your Honor.
Now, Judge Measley, allowed you to keep your breach of contract claim in. She just limited the damages which you could obtain. Is that correct?
No, Your Honor. She said that we were not allowed to any damages. She said that because
she did not. I mean, I was actually have been trying to figure out what kind of damages are left because she didn't dispose of the case, but she did say that there would be no compensatory, consequential, restitutionary, and punitive damages. She knocked those out, right?
She knocked out all the damages we're seeking for the
But
breach
what
of
about,
contract.
like, what about standard breach of contract claims, damages? For instance, she didn't grant summary judgment to the defendant on breach of contract, did she?
Not on liability, but on damages, she did, Your Honor. There are no
So
more.
you're saying she didn't leave you with any kinds of damages? What if you were going to claim that the damages your client had to turn in, that's not the right word. Surrender the policy and got a certain amount back. If you claim that there would have been a lot more that I would have gotten back when I surrendered the policy, if you hadn't upped those premium payments in January 2016, those damages are not available under this order?
No, Your Honor. The damage that was done here, Your Honor, was to the value of the policy. There was a policy here that was paying premiums at the point the rate was imposed, the rate increase was imposed, was approximately $63,000. It was jumped up to $163,000. So I made the value much.
And your claim is, correct me if I'm wrong, and your claim is that what AXA did was wrong because the policy says that to a ratings class, it speaks of a ratings class, and they were not permitted to just take the 70-year-olds. They had to take everyone to spread it out over all age groups.
On some equitable basis.
Right. So that's your claim where AXA went wrong.
On the breach of contract claim, yes, Your Honor.
So does Judge Masley allow you to claim, for instance, that this basically $100,000 bump up in premium for you paid from 2016, is it until 2019?
Yes, approximately.
So are you allowed to claim that $300,000 increase in premium over those years? Are you left with that item of damages?
No, Your Honor. She said, once you surrender the policy, you don't have any damage claims. And that is simply contrary to settled law, which says that when a party breaches a contract, the non-breaching party has the right to terminate the contract, end the contract, and sue for damages based on
But
the
the
loss in
action
value.
your action was not dismissed by Judge Masley, correct?
It was not dismissed, Your Honor. It was eviscerated. She kept the liability, but said you have no damage. No, you won't be allowed to seek any breach of contract damages.
She didn't say that, did she? You couldn't seek any breach of contract damages?
She did. We set forth in our interrogatory responses all the breach of contract damages we're seeking, and she said with respect to each one of those elements, you can't recover those damages.
She
left us with
actually
no.
per se say, I am striking out all possible damages for breach of contract, right?
No, Your Honor, but there's really nothing left because in interrogatory responses, we set forth several theories of breach of contract damages. She struck out each one of those, leaving us with absolutely nothing, which is totally contrary to New York law.
And what is your primary claim as to damages?
It's the loss in value of in the policy.
And what do you estimate that to be?
Approximately $1.5 million. And this is done, Your Honor, on a simple calculation of what the face value of the policy was, and then subtracting the estimated premiums that would have been made had there been no inequitable increase. And just to answer another point that was made about the fact that it was in 2007 that the decision was made to eventually raise rates, we cite substantial evidence from AXA's own records, from its executives, that say that in 2007, AXA had decided that it would raise rates eventually unless its finances changed. And this is at the very same time that AXA is telling Mrs. Hobish and other elderly policyholders that there's a minimal risk of any increase and that this is a good investment
But I mean,
for elderly people.
the contract didn't say we will never increase the premiums. That's not what the contract said.
No, well, there's two claims here, Your Honor. Breach of contract, and the breach of contract claim is based on a rate that is contrary to the provision that all increases will be equitable to everyone in a given class.
And there's a dispute here, Judge Maisley found, at least, that there was a dispute as to what a given class means, right? I mean, you both put in
Yes.
extrinsic evidence because the court found it was ambiguous, and you both put in extrinsic evidence, and she still wasn't sure. She said, well, we're gonna have to have a trial and see what a given class means here.
Yes, but that in itself was an error, Your Honor, because she said that our reading of the contract was reasonable because it was based on the four corners of the contract. She said AXA's interpretation was also reasonable because it was the same as an actuarial standard. She went outside the four corners of the contract to find an ambiguity, and the Court of Appeals has said many times, you can't do that. To determine ambiguity, you have to look at just the four corners of the contract.
Okay, I didn't think she went outside the four corners of the contract to find ambiguity. I thought she found ambiguity and looked to other things to try to get extrinsic evidence to help her make a determination, which in the end she said, I think, she said, I can't really do this, we'll have to have a trial on this.
Actually, on page 815 of the record, she says she's finding that AXA's interpretation is reasonable, and on that basis is finding an ambiguity. And the interpretation she's saying that AXA is giving her is one that is quoted almost verbatim from an actuarial standards manual.
Okay,
It's
well,
not from the four corners
I
of the
was
contract.
actually reading her decision. Okay, why don't we hear from your adversary, and then you'll have an opportunity to respond.
Thank you, Your Honor.
Thank you.
May it please the court, my name is Larry Krantz from Krantz & Berman. I represent Equitable Financial Life Insurance Company.
Could we
And I
start where counsel was sort of left off, which is, given Judge Maisley's decision, given that she did not dismiss the breach of contract action, is there anything left of that contract action given her rulings with regard to damages?
Yes, let me address that issue first. My opponent has misstated what happened below and has misstated their argument below. The problem in this case is that it's an overcharge case. Overcharge damages are the difference between the alleged overcharge and the correct alleged charge. It's very straightforward.
You're saying that the overcharge damages are still alive.
Well, with this caveat, which is quite fascinating. First of all, the numbers cited are wrong. The numbers are in our expert.
So what would overcharge damages be here?
$14,000.
And how do you get to that number?
Very simple. The premiums, the cost of insurance, excuse me, not the premiums, the cost of insurance for this appellant or for the trust went from $7,000 per month to $10,500 per month. That is the increase that we are talking about here.
What about the premium payments that he alleges went from 63 to 163 approximately?
That is absolutely unsupported by the record and incorrect. He is comparing illustrations that were prepared at different times that hypothesize if you paid a fixed amount over the life of the insured, what would you have to pay?
When the policy started in 2007, what were the yearly premiums? What were the payments by Ms. Hobish to AXA?
Your Honor, I can't honestly say.
Was it in the 30,000s?
I'm sorry, Your Honor?
Was it in the 30,000s per year?
If I may step back for a minute, Your Honor, there are two different terms that are being used here that I think it's important to understand. This is what's called a universal life policy. So you can pay in any amount you choose, and then once a month—
There was a cost of insurance part of it, and there was a savings part of it.
Correct. So the question is, respectfully, how much was the cost of insurance at the beginning? How much was the cost of insurance, which is a monthly deduction from the policy account. And in this case, and it's at A1254 to A1255, the cost of insurance monthly deduction at the time of the increase went from $7,000 to $10,500 per month. That is the correct differential. Now, the trust voluntarily surrendered the policy.
I don't know how voluntarily it was, but they did surrender it when?
Well, they had, first of all, they had to pay nothing for 3 years because there was sufficient value in the trust, in the policy. They had to pay no premiums, not one penny, for 3 years, and the policy account.
And you took those those premiums out of the balance on the policy, right?
Correct. But that's a balance that did not ultimately go to the beneficiary anyway at the time of the death if the policy had remained in effect.
If it had remained in effect, it would be a $2 million policy, right? I mean,
That's
what
correct, but they had every right to keep it in effect, and there are emails in the record.
But obviously they did an analysis before they got rid of the policy, and they said, my goodness, if these prices keep going up like this, there'll be nothing left in the policy, and then you'll cancel it.
Respectfully, Your Honor, the cost of insurance goes up as the insured ages under any scenario, even
What would
without
have
an.
happened to the savings portion of what Ms. Hobish had paid if it was kept until she passed away? There would have been
Savings would revert to the insurance company. She chose what's known as option A. There are two options. One is where the amount in the policy account at the end goes to the beneficiary. That's option B.
I know that this matters to the appeal, but if it goes to the insurance company, why would someone put money into that account?
Sorry, why would what, Your Honor?
Why would someone put money into that account?
Because it's the goal of this policy, it's a universal life. The idea is to fund it at a level over your costs at first, get interest on it that builds up, and then when you are older and your costs of insurance are higher, you have value built up that will offset or pay those premiums. So the goal for most people is to find a level premium.
But so if the premium, but did the premium go up like he said?
No, it did not, Your Honor. It did not. The cost
of insurance did go up.
The cost of insurance went from $7,000 a month to $10,500 per month. She kept the policy in force for 4 months, resulting in damages of $14,000.
When was the policy surrendered?
July of 2016, 4 months after the increase.
After the increase, and she passed away in September of 2019.
Years later, but their action is brought long before she passes away.
Right, I understand.
Their position is that simply because of the breach, they are allowed to collect the surrender payment, which is a benefit under the policy, pay no more premiums ever, and collect the face value, the death benefit value of the policy. This would mean, honestly, if you think about the number of policies affected by the increase, if every policyholder had the right at that moment to simply cash in the policy for its face value, we are talking about a multi-billion-dollar exposure on the part of the insurance company for any material breach, in their view. If I could say one last point, Your Honor.
Sure.
The reason that the court has not left any damages in the case is because they don't like the $14,000 number, which is the correct valuation of the case, so they have not asked for it. That is why there's nothing left. They don't seek the $14,000 because they prefer to come to this court and say, we have no remedy. But they have no remedy because they have forsaken the correct remedy.
And what do you say the correct remedy is?
$14,000. It's an overcharge case.
All right.
So if if they prevail on what the meaning of a given class means, that's AXA's sole exposure?
Yes.
So are you telling me that the premium payments didn't change? I mean, where did he get that number?
It's only the cost of insurance that matters. The premiums are what the policyholder chooses.
So
to
that's
pay
like the
in.
savings portion? Is that what the premiums sort of are?
Let me put it this way, if I could. If you put in $6,000 and the cost of insurance is $3,000 that month, you'll be left with $3,000 in your policy account, which will be used in the next month to pay the cost of insurance.
And then you'll have nothing.
Well, you'll have to come up with additional money to cover the cost of insurance.
I'm struggling to understand the economic sense of this for someone who's buying this policy, because you're paying into this savings account, which at the end you get nothing because she took an option which gives the money to AXA. What was the interest rate on the savings portion?
Guaranteed at 3%. I believe it could be higher, but the guarantee was 3%. And again, the idea is that you try to establish a level contribution. You can call it a premium if you want.
So to someone who has assets, as Ms. Hobish did when she bought this policy, although she subsequently didn't,
yes,
there's no reason for her to be putting money into this savings account, because she's better off to just pay the cost of insurance as it comes due.
Well, that's an option that anyone is allowed to do under the policy.
At best, it makes sense, but to, maybe have enough money there for a month or two of payments to be sure it gets paid. But over the life of the policy, there's
Your Honor,
nothing in it.
this is a decision of the policyholder. There's no requirement.
I understand.
There's no requirement to overfund. If you want to minimally fund, which is what it's called, you can do it.
Okay, and just what did she put in to open this account?
In my recollection, she sold her prior insurance policy, which was a Lincoln Life policy, for something in the neighborhood of $600,000.
And put that in there.
And deposited that in. So that now goes into the policy, and once a month, there are deductions. At the time of the surrender, the policy value left was about $435,000. And they made a decision.
And that's what you gave them? That's what
minus a $35,000 surrender.
Surrender fee, okay. All right, we've asked you a lot of questions, taken a lot of time. You each have 2 minutes for rebuttal because there are cross appeals.
Your Honor, counsel was totally wrong on the number.
But it sounds like you put in $600,000 in order to get $400,000 back.
Yes, and when he says that, oh, it was only going to go up $14,000, he's leaving out the fact that if that's the option that was chosen, then the savings account would have been depleted very quickly. And that's the whole reason that AXA does give these illustrations, because it tells the policyholders what happens if you just draw down the savings account or you put in money.
If you just draw down the savings account, pretty soon you're not going to have any money left. And that's what, $10,000 a month is pretty substantial payment.
And it's more, Your Honor. It went up over $100,000. The illustrations that...
What went up, I'm sorry, what went up over $100,000?
The amount she would have had to pay in order to keep the policy alive to the age of 100.
But he said, your adversary said that the cost of insurance, the monthly cost of insurance that got taken out of the amount, and I'm looking at his chart, the pages he said, was about $7,000, and then it was going to go up to like $10,000, but that was after you took it
It
out.
would go up year after year, plus her savings account would be depleted by a greater amount year after year, plus
her savings account would what?
Would be depleted because they'd be taking money out of the savings account.
Right.
But it's not more than
by a greater amount.
But it's not being depleted more than the $3,000 increase in the cost of insurance for that year.
Oh, it is indeed, Your Honor.
Why?
That's why, because the way AXA calculates this is they take out a certain amount and they have a formula to do that. And that's the whole point of the illustration. You have to go to the illustration to see what the actual economic impact is. in the
You
illustration.
mean it's more than the $7,000 a month for
Exactly.
the cost of
Yeah.
insurance they were taking out?
Yes.
What were and what was that called? What was that?
That's what the illustrations show, Your Honor.
Where's the illustration?
Your Honor, the illustrations are in the
I mean, it's in,
record at,
where in the record is the illustration?
yes.
All right, well, maybe while your adversary's speaking, you can find it.
Okay.
Because
I
I don't
should be able to
want,
find it just-
I don't want to make you look through all these pages. Is there anything else you feel you didn't answer, or, I mean, that you absolutely have to respond to? Otherwise, I'm going to listen to the other side.
Yes, yes, Your Honor. The illustrations at pages A533, A549, A1149, and A1167. That shows that in order to keep the policy active up to the age of 100, you'd have to pay premiums of this amount, $63,000 before the increase, $164,000 after the increase. They're playing with numbers when they're saying, oh, we'd only take out $7,000 for the first month, but then the policy would not be
But you
active.
didn't get to those numbers, did you?
I'm sorry?
You didn't get to those numbers because
No, because she
Did you-
decided,
you surrendered the policy.
and she has the absolute right to, once a party breaches, Your Honor, you don't tell the non-breaching party, oh, you have to stay in this contract that's bleeding you dry, and if you give up the contract in order not to become penniless, you have no claim. That's not New York law. They're seeking to reap the benefits from a bait-and-switch scheme. Because, Your Honor, I'd also point out, that's not just a breach of contract, it's also the Section 349 claim.
Yeah, and that was left in also.
But no, Your Honor, she said there are no damages under Section 349.
So why didn't she just dismiss your case if she
Because
didn't think there were any damages?
Because there's a statutory damages of $50, Your Honor. That's what she left in on
Okay,
349.
okay, thank
Now,
you.
just, if I could just, one final point. The Guyden case, Guyden versus Guardian Insurance
Yes.
case, dealt with the same issue where the court said, it doesn't matter whether or not you have a breach of contract claim, you still have a Section 349 claim. And she said on no basis whatsoever, since you have no breach of contract damages incorrectly, I don't think you have 349 damages either. That's totally unprincipled, and we ask you to do justice for Mrs. Hobish, Your Honors. Thank you.
Okay, thank you. Counsel, you have 2 minutes.
As the plaintiff in the breach of contract action, it is their obligation to put forward a damages theory that is consistent with the law and non-speculative, right? Then you get to a jury on your damages theory. Here, the only damages theory that they put forward is we, the plaintiff, are entitled to the $2 million death benefit minus the $400,000 you previously gave us. That is what Judge Maisley rejected, because that, frankly, is a completely absurd damages theory. It just cannot be that because there's a monthly overcharge, they get to simply collect the death benefit despite the fact that the insured is living and the policy is terminated and surrendered, and they're paying no more premiums. That is a windfall.
Is there any theory that the reason why the policy was surrendered, therefore maybe entitling them to greater damages, is because she was in effect forced to, based upon the higher increase in whatever payment, premiums, policy, overcharge, well, however you want to call it, but it was a class of people directly targeted, 70 plus having a certain amount of money, and therefore she was forced to. Is there any theory there?
Well, Your Honor, they have raised that theory in their appellate papers. They did not make that argument below. But if I could say, the proof of the falsity of that theory is twofold. First of all, if you read the internal family emails, you will see that this is a completely voluntary decision to put assets into their mother's pocket while she is alive, rather than waiting for her to die and benefit themselves. That's one. Number two, if you look at the data after the increase, 1,670 policies are affected by the increase. The number of surrenders, 10 in 2.5 years from the increase. Less than 1% of the policyholders surrendered their policies.
There's a class action in the
Yes.
federal court going on right now, am I correct?
That is correct.
And are the claims the same as the claims?
They overlap. There are similarities. There are differences. That class action is largely over its breach of contract, and it's over the illustrations that were given. In this case, plaintiff
Ones he
acknowledges,
just referred to?
plaintiff acknowledges that they never read the illustrations, and so they have no claim. They admit that. They have no claim over illustrations. And frankly, they completely misunderstand the illustrations, which are not costs themselves.
Counsel, I have one more question.
Sure.
When you refer to the surrender as voluntary, how do you understand with that the fact that when she sent that surrender letter, it also said under protest? Or do you
Well, she can
disregard
say
that?
whatever-
What does
She
that,
can say
what does that
whatever she
mean?
wants in her surrender letter, but the decision to surrender the policy, you really, if you look at the email
But
traffic,
doesn't under protest mean something?
well, she wasn't waiving any rights that she may have had, but if she didn't have rights, she wasn't getting them by saying under protest. And the point is that under the policy, you can't surrender it and get the surrender payment unless the policy is in effect. It's a benefit under the policy.
So just one other question. So your adversary said that there were additional costs being taken out in addition to the cost of the monthly cost of insurance. I thought that's what I
Incorrect.
heard him say.
He does not, respectfully, he does not understand the policy. The monthly charge is simply the cost of insurance plus a minuscule administrative fixed charge. That is the monthly
And then,
charge.
and it's everybody's choice who had these policies, if they wanted to invest or put in some additional money to get the 3% and help pay out the monthly cost of insurance payment and administrative fee.
Correct.
Am I
You
right?
can put
Is
in
that what
as
you said?
much or as little as you want, whenever you want, so long as at the end of every month, there's enough to cover the cost of insurance and the small administrative charge.
Okay, thank you. You've answered all of our questions, and at least for now. And thank you very much. We'll take a look, further look. Thank you very much. People versus Ruiz. Oops.
Uh-oh.
It's like a cartoon. Okay, you can start, please.
Sure. Good afternoon, Your Honors. My
Good
name is
afternoon.
Claire Pierkowski, and I'm a law student in a criminal defense clinic at Cornell University, appearing for Mr. Ruiz. I'm under the supervision of the Center for Appellate Litigation. The court below erroneously authorized a general warrant for evidence of criminality that permitted a search of the following areas of Mr. Ruiz's cell phone: telephone numbers, all stored digital messages, directories of phone numbers, email addresses, and
Yeah,
contacts.
I know most of us took a look at those warrants. So are you claiming, how should they have been reined in or not quite as broad as they were? Because they certainly were very broad warrant requests.
Your Honor, the warrant should have been sufficiently particularized as to both the scope and duration. In regards to scope, they should have essentially proffered details that would support a reasonable belief that evidence would be found in all the locations of the cell phone of which they wanted to search. And the temporal limitation should have been limited to something much less broad, such as the day of the crime. There was no
What evidence emerged from that warrant that was used at trial?
The evidence that emerged were text messages sent from Mr. Ruiz's wife, and these messages were repeatedly referenced.
Let us say we agree with you that it was overbroad and that those text messages should not have been utilized. Is the error that we're talking about subject to harmless error analysis?
Yes, Your Honor. The text had a rational possibility of contributing to the verdict as they attributed a motive to rob to Mr. Ruiz. This was something that the people even told the jury was an important factor to consider on summation. And it's harmful because it rebuts Mr. Ruiz's credible testimony that he had no idea the robbery was going to happen and that the second
It
perpetrator...
also provides some element of motive for the crime.
no,
Text messages.
no, Your Honor. It was not an element of the crime.
The need for money, not an element of the motive for the backdrop for why the defendant may have been involved in this, because he is being asked to bring home money.
Yes, Your Honor. That was why the people referenced the messages multiple times, to use those text messages saying to bring home money. That was something that why he would have a motive to assist the second perpetrator. And
in the face of the video evidence which exists against the defendant, doesn't any error that those text messages may indicate, aren't they harmless beyond a reasonable doubt?
no, Your Honor. The video evidence actually did not capture surveillance of the physical incident itself. All that it shows is that the defendant was in the area that day.
I know that, but it captures the clothes change, it captures the clothes, it captures the fact that he's with T, and the defendant himself says that T is the guilty party. So it's pretty strong evidence against the defendant that emerges from the video, in conjunction even with the defendant's own testimony.
Your Honor, Mr. Ruiz credibly testified that he did not know that the robbery was going to happen, and nothing in the record explicitly refutes that. And in addition to there not being evidence of the robbery itself, there also was only one eyewitness who didn't see the actual incident occur. There was no recovery of any proceeds or the necklace itself.
Does the fact that he changed his clothes so quickly thereafter and then was found maybe hiding someplace, is that evidence any consciousness of guilt?
No, Your Honor. Mr. Ruiz credibly testified that he didn't want to be associated with criminal activity as he had a baby due the next day and wanted to come home. And the warrant also, in addition to being insufficiently particular, lacks probable cause. The people are advancing an argument here that police have probable...
You say that he credibly testified, but obviously the testimony wasn't credited. I mean, you know, someone might think, having seen this crime, which is what you're saying happened, that the defendant saw the crime, that maybe what he would have done is run to see whether he could help the victim if he wasn't involved in this occurrence.
Your Honor, while that's true, Mr. Ruiz, did testify to his reasons for not stopping to help the victim and changing his clothes, and that he feared that he would be associated with a robbery that he did not commit, and he wanted to ensure that he would be able to be there for his family with the birth of his child approaching the next day. And the people are advancing an argument here that they can essentially search the entire contents of a cell phone merely just because a suspect has a cell phone on their person or drops it at a scene. This court must reject that argument, as recovery of a phone from a crime scene with an assumption that it may contain evidence is not enough to establish probable cause here. A search warrant has to support a belief that evidence of illegal activity is going to be found in each particular area of the phone, and the search warrant offered no such reasoning. And for the reasons stated here today, Mr. Ruiz's convictions must be reversed and a new trial ordered. Thank you.
Okay, thank you. We'll hear from the people, and you'll have a couple moments for rebuttal. Thank you, Kim.
Good afternoon, Your Honors. Jared Walkowitz for the people. There is no doubt that the information in the warrant from paragraphs A through D were appropriate in this limited circumstance for what the phone was being asked for in this particular case, which was evidence of ownership. See, when they were talking about probable cause, they said, well, a phone from a robbery. Well, if we just recovered his phone from a robbery, from his body, then they may have a point.
Had he not already identified that phone as his property?
Yes, but he also testified incredibly, one. Two, that doesn't stop us. We've cited People v. Alvano, which is a Court of Appeals case, from submitting all the evidence of his ownership. So the fact that he admitted that it was his...
Yeah, but it wasn't just the evidence of his ownership, because there were specific text messages that pointed maybe towards motive. I think that's the problem here.
Well, no, the text messages do point to motive, but it's a question of how did the people find them? Did they find them in a proper way? And in this case, they
Can we agree that warrants, when they're issued, shouldn't be overly broad? They should maybe be specific in temporal proximity and things of that nature? And this wasn't, and there were other warrants in this case that did meet that burden. It wasn't particular to this warrant where the text messages came from.
Absolutely, Your Honor. I agree with that, except for one thing. What are we seeking the warrant for? We're seeking it here for ownership information. And ownership information is not appropriately limited by a time period. If I register a phone in January of 2020 and I commit a robbery...
Wasn't there a part of the warrant, I think it was Section E, that said that tends to show that defendant was engaged in crimes? That has nothing to do with ownership. The warrant listed different areas that it sought to recover, not just ownership. You already had that.
We've conceded portion E is arguably overbroad, and it's not towards ownership, and that's not what we're defending here. We're not defending Section E at all. E is a separate section. If you look from A to D, those are, D ends with the owner of the primary user of the target device and his other contacts. The telephone numbers, so that would be what registered to the device, so that would be his ownership information. Stored messages, that would be him using the phone, use of the phone, whether it be voicemail or email. And all of that in C and D, directory of numbers, email addresses, showing who that he's using the phone, communicating with friends, family, all ownership information. And then pictures, showing him in the pictures, video recordings. This is not a case where there's internet usage like in Thompson. This is a case where it was clearly stated what the purpose of the actual warrant was.
But I think that regardless of what is stated, what the purpose was, it went beyond that. It went way beyond that, because you got a lot of information from that phone that you later used at trial.
Well, let's
more specifically the 3 text messages.
May I respond? The text messages quite easily satisfy that, because text messages show that a user is using the phone. The phone is on the ground, dropped by.
But you didn't use it at trial simply to show that that was his phone. You used it at trial to show that somehow he had a motive to go out and commit a robbery.
Well, respectively, Your Honor, we didn't know that when we wrote the warrant or when the motion to controvert the warrant was up. They conceded identity at trial. So that's not a basis to eliminate evidence that is properly recovered. It's just not, because, again, as I said, the moment he signs up for that phone, to the moment that phone is searched, or to the moment of that crime, it is evidence of ownership, and it is absolutely relevant. It's greater evidence the older it goes, right? The more he used it, the more that it's his phone. He dropped it at the scene.
But if he has already conceded when he gets arrested or when he's taken to the precinct and he showed the phone, that it is his phone. He says, yeah, it's my phone. What more do you need?
One, we don't have to introduce his statement, because he could have other statements, which I don't believe, again, I'm almost on cross-examination, we may have crossed him about a statement, but we never introduced his statement in our direct case. It's hearsay, for him to introduce it. So we have no idea if that statement will come in because he may put in exculpatory facts. So we don't know at that time whether we're going to use that statement when we write the warrant or not. What we're focused on, at the time, is proving that the phone that was dropped was his phone. And if you look at the application, as I said, if you look at the application, it is all over ownership, identity of the second perpetrator. Now, paragraph E, I admit, as I said, that if that was what the warrant was totally based on, we would lose. But that's not what it was based on. And if I can, I see my time has expired, but obviously for the reasons that were discussed with my counsel, with my adversary, this is completely harmless. It goes strictly to motive. There is a videotape of the entire incident, and I'm sorry.
Well, not
the
the
entire
entire
incident. No, I take that back. I said
Kind of missed crucial parts of it, but.
Right, it missed the actual robbery.
Yeah, right.
So I admit I made a mistake.
Yeah, that's okay.
But it caught the before and after of the robbery. Yes. And we would say that what?
And the clothes change.
The clothes change, and yes, and we would just ask that the conviction be affirmed, even if the court were to find the warrant overly broad, that the error was harmless.
Okay, thank you.
Very much.
Okay, you have 2 minutes for rebuttal.
Your Honors, I have 2 points I'd like to make briefly. The first being that as much as the people contend that the search warrant's purpose was to establish identity of the phone's ownership, the search warrant's purpose was, incidentally, to search for evidence of criminality. If you look at the search warrant and the search warrant application itself, it mentions evidence of criminality just as many times as it mentions identity. In addition to paragraph E, which my adversary mentioned, it's also mentioned on page 1, paragraph 2, page 2, paragraph 6, pages 3 to 4, paragraph 7, and page 6 and page 6, paragraph E. In addition to this, I would like to speak to the harm component. This was not harmless error. Without these texts, there is a rational probability that the motive to rob would not have been evident to the jury. Mr. Ruiz was anticipating a paycheck of $850, and if he wasn't able to obtain it that day, he was able to obtain it sometime later that week.
Does it matter that the court credited the testimony of the complaining witness that he was attacked and robbed by 2 individuals as opposed to just the one?
Your Honor, the complainant's testimony was quite inconsistent, as he had previously told detectives very conflicting evidence. He had said things such as, he at first said one man was on a bike and the other was on foot. He then later said and insisted at trial that it was 2 bikes, even though the video evidence clearly contradicted that.
Right, but the jury still credited his testimony, even knowing all of it, right?
Yes, Your Honor. However, there is a rational probability that the evidence here was harmful in light of the jury's verdict because guilt was not overwhelming. And if there are no further questions, I yield the rest of my time. Thank you.
Okay, so we want to thank you. I know you indicated at the beginning that you're with the Cornell Law School externship program, and it's very nice that you had the opportunity to come and speak to us, and we're happy that you had that opportunity, and we did too. We did a great job.
you.
Everybody did, and best of luck to you in the finishing of law school.
Thank you, Your Honor.
And our last case for argument is Storch Amini versus Schlackett. No, over there. Okay. All right, why don't you go ahead and start?
Good
Thank you
afternoon,
very
Your Honor.
much.
Jeffrey Chubak of Amini LLC for the plaintiff appellant Storch Amini PC. Storch Amini represented Laura Prochotko in a contentious divorce proceeding that was commenced by the respondent David Schlackett. The reason we're here is because after she was found dead under extremely suspicious circumstances, Mr. Schlackett took control of her share of over $7 million in jointly owned real property and refused to pay her outstanding legal bill, leaving us no recourse other than to seek to recover from the inherited IRA that's at issue in this appeal. This appeal concerns two issues that weren't addressed in the prior Cohen-Goldstein appeal. First, under the trust exemption, not only must the fund at issue be deemed a trust, either under CPLR 5205C2 or independently, the trust exemption itself only applies to, quote, property while held in trust for a judgment debtor, end quote. It can't.
Why isn't this issue resolved by our prior decision, in Cohen-Goldstein versus Schlackett?
For two reasons. First, it can't reasonably be disputed that the cash and securities on deposit in Mrs. Prochotko's IRA weren't held in trust for a judgment debtor after her death. And as to the transferee account, that's not held for a judgment debtor either, because the contract claim was against Mrs. Prochotko for legal services rendered, and any fraudulent conveyance action is expressly preserved.
At bottom, isn't your argument that we got the Cohen case wrong because 5205 subdivision C says C subdivision 1, except as provided in paragraphs 4 and 5 of this subdivision, all property while held in trust for a judgment debtor. And this property is not being held in trust for a judgment debtor at this point, but for the judgment debtor's heir.
That's exactly correct. And as to the...
I don't know if it's exactly correct, but it's exactly your position.
that is exactly our position.
It may also be correct, I'm not saying.
The other issue is whether the inherited IRA is exempt based solely on its status as a custodial account. The federal district court decision cited in Cohen versus Goldstein, Todd versus Endurance American Insurance Company, rejected the argument that an inherited IRA is exempt so long as it's one of the assets covered by Section 5205C2. It held, this argument reads out of the statute the limited enumeration of persons who may enjoy the benefit of the trust exemption. And as noted by the Todd court, an inheritor to an IRA is not one of the categories of judgment debtors enumerated by the statute, and therefore an inherited IRA is not exempt under the trust exemption. The fact that the inherited IRA is a custodial account doesn't negate the requirement that its owner...
Let me ask you this. Is it also sort of your position that it's the husband who puts this money into an IRA for the son, right?
Correct. It was the husband who rolled over the IRA.
Even if that is somehow exempt under the statute, but in him taking that money and emptying the estate of assets to pay its debts, it's a fraudulent conveyance.
Correct. That's the claim we asserted in the motion court. We brought fraudulent conveyance claims and made a summary.
So maybe that account is exempt. Let's assume that for purposes of argument at the moment. But does he still have a liability as someone who's engaged in a fraudulent conveyance?
I'm just asking this question to clarify. When you say, does he have a liability as someone who made a fraudulent conveyance, you're asking...
The husband in putting the money into...
Well, the person who has liability in relation to a fraudulent conveyance, which is just a deemed fraud, it's not an actual fraud, is the transferee. And the owner of the account is David Schlackett as custodian.
Mm-hmm.
And
That's the husband, right, David?
That's correct. And with that,
But in putting the money in like that, he engaged in a fraudulent conveyance. Isn't that your position?
Yes, and respondent's position is he was just effectuating the designated beneficiary instructions that are in the account opening documentation. But our position is that that's still a fraudulent conveyance. When you're transferring property and the transfer is made while the...
Because even if that account is, let us say, exempt, but for him to make the estate unable to pay its debts by doing this, That's a fraudulent conveyance.
Correct. And we'll point out that the second department held that much quite recently in the context of a case that didn't deal with the infant issues presented here, but held that an IRA transfer to the designated beneficiary is still a fraudulent transfer. That's cited in our briefs here as well. Thank you.
Okay, thank you. Can we hear from you, please? The respondent.
Good afternoon, Your Honors. Anna A. Petito for the defendant respondent. I'm representing Andrew Z. Law today. I just want to start off by saying that there is nothing new presented in the appellant's application. The fact remains that there was no fraudulent conveyance as during the 6-year statutory period after the...
Let us suppose that we did misinterpret the statute in Cohen. Is there anything which prevents us from coming to a correct interpretation of the statute?
Yes.
I mean, what do you do with the fact that 5205 C1 says all property while held in trust for a judgment debtor? This property is not being held in trust for a judgment debtor now.
The son, Talon Schlackett, who the IRA was created for, he is not a debtor. He is a vested beneficiary of the account, and during the statutory period...
So doesn't it on its terms, C1 not apply to him?
I'm sorry, could you repeat
Doesn't
that?
it on its face, doesn't 5205 C1 on its face not apply to him?
It does not.
Well, then he's not entitled to, then this account is subject to being collected to pay the debt, is it not?
It's not subject to being collected because during the 6-year statutory period when the IRA, it was created in 2009, so 6 years after that, any fraudulent conveyance claims should have been asserted, and there were none. The beneficiary was vested in 2009.
Wait a second. The time doesn't start running from the time that the IRA account was opened. I mean, there was no fraudulent anything then. It was only after the wife died and that they moved it. That's when the fraudulent conveyance happened. So isn't that when the statute of limitations begins to run?
Well, the wife died and then the beneficiary is now activated. The status of the asset is never really hers or the child's. It's this independent status. And then after she passes, when his father, Mr. Schlackett, moves the assets from one to the inherited IRA, that's not actually a fraudulent conveyance. He was just enforcing.
Are you asserting a statute of limitations type defense to this?
Yes, because...
Is that the argument that you made in your brief for an affirmance?
Could you repeat the last word?
Is that the argument you made in your brief in favor of an affirmance?
No, but we are saying that Mr. Schlackett was enforcing the property rights of his child. He wasn't making a fraudulent conveyance. He was assigned as guardian in May 2019, and as being in charge of the minor's assets, he had to do what he had to for the asset. Frankly, there was not a fraudulent conveyance at the time that it was created. And I have nothing further to add.
Okay, thank you very much, counsel. You have 2 minutes for any rebuttal.
I'll be very brief, Your Honors. First, the statute of limitations defense was not preserved, and also it only begins to run from the date of the transfer. The transfer didn't occur until after Ms. Prochatko's death, which occurred in 2018. The statute of limitations for pre-2020 transfers is 6 years. We're well within the limitations period.
So the statute of limitation, you say it wasn't preserved. Did she ever raise that statute of limitations?
It was never raised. It was never raised. But I'm addressing it right now. And
yes.
It's certainly not in her brief here.
Right.
Yeah, and as to the independent status, the transfer having been made after Ms. Prochadko's death, it's a transfer. It was made from her IRA account to an IRA account titled in the name of David Schlackett as custodian for their son. The fraudulent conveyance laws don't really concern who controls the transfer. There's no requirement that she be alive at the time of the transfer. It only looks to whose property was transferred and the circumstances under which the transfer was made. And it's not really disputed that the transfer was made while she was insolvent or left her insolvent as a result, and that we've made a prima facie claim for fraudulent conveyance. Really, the only issue on this appeal is the one that was previously decided in Cohen-Goldstein, application of the trust exemption to the transfers at issue. With that, I'll yield my time. Thank you, Your Honors.
Thank you. Thank you both very much.